Any mention in the list? My lord, I want to mention these three matters. These are contempt applications, my lord. Order was passed by my lord Justice I.P. Mukherjee and my lord Justice Mosmi Bhattacharya. So, my lord, I say, my lord.
Are the matters pending over here or before the principal bench? Then what is the use of mention? File has to come, make the requisition.
So that next circuit at least.
Yes, yes.
Mention in the list. Item number on WPCT 49 of 594.
My lord, I have very possible petition, my lord. My lord, these petitioners.
As I have received the brief just now, but he can make his submissions in case I require time. I'll request you.
What happened, my lord? These petitioners are having graduation and diploma in pharmacy. The administration published a vacancy notice in 2018, whereby invited application to fill up the post of pharmacist. Subsequently, due to administrative reasons, prolonged, my lord, and ultimately on 10th of January 2024, one more vacancy notice was published, whereby in consultancy with 2018, all those who applied, they can appear in the said vacancy post, my lord, because age will not be a criteria, because 2018 to 2021, 2024. Now, my lord, in terms of the said vacancy notice, my lord, the conditions which are being postulated, the clauses says that the computer-based examination will be conducted to the syllabus within 2 years of diploma course. That would be the syllabus. Now, my lord, examination was conducted. Admit cards were received. We were shortlisted since we qualified. We were shortlisted. Examination was conducted. When the examination was conducted, it was found, when the answer key came, it was found that at least, my lord, in some there were 4 set of question papers, my lord. Examinations were held in 9th March and 10th March, morning and evening shift. Now, my lord, it has been found that at least 10 to 12 questions in each set, that is in morning 9 and 10th morning and 10th evening, are more than that's of the higher education, that is of bachelor degree and all. Now, my lord, we raised our objection and certain answers were wrong. We raised our objection narrating that these are the questions which are wrong and these are which are out of syllabus. My lord, that objection was never considered. Subsequently, my lord, on once again, my lord, they have issued on 6th of October 2024 a revised answer key, whereby only 7 wrong answers were corrected, my lord. So far as this part is concerned, that was not addressed at all.
Which part?
That higher syllabus, because
all right, higher syllabus.
Yes, my lord. My lord, they cannot travel beyond the scope of the clause of the vacancy notice, my lord. Now, my lord, we challenge this act.
Has the result been declared?
The result, no, the answer key was there.
All right.
They prepared a short listing and a select list was made.
So you were not in the select list because you say the
yes, my lord.
Questions were from a different syllabus or a higher syllabus, wrong, everything.
My lord. Now, my lord, we challenge it before the tribunal, saying that, my lord, they cannot travel beyond the scope of the vacancy notice. Now, my lord, along with the original application, I have also sought for an interim order, saying that the select list ought not to be given effect, my lord. Now, my lord, tribunal on the very first day accepted my argument that it will vitiate the entire proceeding, granted a stay order, but relegated the matter back to the authority, saying that you decide. Now, the question is that, my lord, this cannot be decided even by the court or by the authority, because it's an expertise job, whether answer is correct or not. Now, it is our specific government that these are the answer, my lord. I prepared a chart with the help of my clients, wherefrom it reflects that these are the questions, because I have put the syllabus of B Pharmacy in my application also. And
is the chart here?
Yes, my lord, everything is there.
Well, which page?
My lord, chart, I have got the chart in the chart, my lord. I have categorically said.
You want an expert body to be set up to evaluate
it. How the authorities can evaluate it. And I'm sorry, my lord. I'm extremely sorry. Yes. Extremely sorry. Now, if my lord sees, kindly come to second page, third page onwards, my lord. Now, my lord, in set 1, my lord, 6 questions are from the pharmacy, my lord.
Yes.
We have given the page number of the syllabus also, which is there part of our writ petition. Now, my lord, if my lord sees on 10th March 2024, this is the morning set, my lord will find 18 questions are from the set syllabus. Thereafter, my lord, in the last set, there are 14 questions. Now, my lord, what I am on, my lord, once you travel beyond the scope of the vacancy notice, it vitiates the entire proceeding. And my lord, the learned tribunal also said so, and learned tribunal stayed the select list for a specific period till the authorities consider my representation.
Show me that order.
My lord, may kindly come to the head volume.
Which page?
My lord, page 509.
Yes.
And my lord, this order which my lord sees is order dated 12th of November 2024, but it was uploaded only on 27th of November 2020. Now, my lord, may kindly come to page 511, my lord. In the instant case, counsel for the applicant submitted as per the notification for so and so, these are the post, my lord. 6, para 6 says, by the learned counsel for the applicant that as per para 4 of the note, the following essential qualification. My lord, page 512, para 7 is relevant, my lord. As per learned counsel of the applicant, para 8 of the said notification deals with the recruitment examination, wherein under the heading Pharmacist grade 3, it has been specifically stipulated that questions from the following topic conforming to standard of 2 years diploma in pharmacy course would be met. In pursuance to the said notification, all the applicants have appeared in the said examination, which was scheduled on 9th of 10th March 2024 in 4 shifts. However, after getting the question paper, it was found that some of the questions are beyond the standard of 2-year diploma in pharmacy, the standard of degree in pharmacy. In this regard, the applicant has made representation in detail showing the question, syllabus, etc. However, as per the learned counsel for the applicant, till today, the applicant have not received any communication in respect of their grievances. As per the learned counsel for the applicant, those questions are out of syllabus. Now, my lord, may kindly see paragraph number 530 is the stand of the authorities, my lord. It says, learned counsel for the respondent has submitted that after receiving all type of objections from different candidates, including the present applicant on the above said examination, the expert committee agency has rectified it. My lord, no question of rectification. If a syllabus is on and above, how it can be rectified? Because there were twofold argument, my lord. First is some of the answers were wrong. Then it says, my lord, it was found that 7 questions are beyond the scope of the notification, which was rectified by granting grace mark to all the candidates. However, learned counsel for the respondent submit that they have already communicated the reply to their queries objection to all the candidates. Now, my lord, pausing for a minute. If this is the stand of the authorities and authorities say that already we have communicated, there is no use to relegate the matter before the authorities. When I have a specific case saying that these are the questions which are out of syllabus. Now, my lord, thereafter, however, so and so. Now, my lord, para 11, the court says, during the course of hearing, the learned counsel for the applicant had submitted that it would suffice its purpose for the authority if the authorities be directed to consider the representation. My lord, this was never, because 12th hearing was taken, the order was uploaded on 27th of November. Representation in true spirit and letter which has been submitted before the authorities, treating this OA as part and communicate the action, if any, by answering their grievances within the stipulated period of time and in the interim of the said select list may not be given effect. In view of the above, though the respondents have been claiming that they have already answered to the queries objection made by the other candidates, including the present applicant, since in the instant case the main issue is as to whether the questions are beyond the scope of the condition stipulated in the notification or not. In this background, the respondent number 5 is directed to consider the representation of the applicant treating this OA as part of it and communicate their action decision to the applicant by way of a recent order within. It is made clear till the communication of the reply are made, respondent are directed not to be affected like this. Now, my lord, my contention is that, my lord, once the authorities have taken the stand before the authority, there were only 7 questions which ought to be corrected. We have corrected, we have communicated. Thereafter, relegating the matter to the Andaman Nicobar administration, who are not an expert body. no purpose will be served, my lord. Today they will pass an order and say that the selection is, because they specifically say, we have communicated to the applicant also. My lord, I pray, since it's a duty, my lord sees respondent number 6 in the instant original application is a body which has conducted the examination. Page 4, my lord will find.
Respondent number 6 is the secretary. Health.
My lord, 5 is the commissioner who has been directed.
Yes.
And my lord, respondent number 8 is the body who conducted
Body.
the recruitment process.
Right.
Now, this body has a very, such is the reputation, my lord. One more matter is coming on Monday, which Mr. Jaipal is arguing. The court directed them to correct it. Once they corrected, thereafter again there were 7 to 10 questions wrong. That is a subject matter in another. So, my lord, this body cannot be allowed to, my lord, they cannot be a person to judge their own wrong, my lord. So, some authority, my lord, once it was happened, my lord, in one matter, when I was appearing for a person, he has submitted certain certificates. And my lord, the authorities have not accepted, administration has negated it. I approached the court, court sent it to an expert body. Expert body given an opinion that his certificate is at par with the law. On the basis of that, my lord, subsequently that person has got job and is working under the act. So my contention is that, my lord, any
Expert body.
independent body may be given till such time, my lord, when the report comes, at least a week time thereafter this may be stayed. Time frame, whatever comes to my lord.
And not this, the WPCP is not maintainable at all. And we have para 11
Of.
of the impugned order page 513.
That I have read.
In the course of hearing, learned counsel for the applicant has submitted that it would suffice its purpose if the authorities be directed to consider representation of the applicant in their next two letter and spirit, which they have submitted before the authorities, treating this OA as part of it and communicate action if any by answering the agreement within stipulated time. So why not? This is a consent order. It has been passed on their submission. If they have a problem with this, they have to file a review application before the original authority, before the CAT. They can't challenge the order after it is recorded in the order that it was passed at their instance and at their request. It's not fair to the tribunal.
My lord,
If they are saying that this is an erroneous recording, I'm not disputing. My learned senior is submitting, I'm not coming in the way of that. Then they have to apply to the tribunal, file a review or modification application.
page 42.
How can they file an appeal?
Page 42.
Please wait. Yes.
So, my lord, my submission is they have themselves invited this order, my lord. If they have there is an interim order, they are not prejudiced in any way. They can just they can apply to the CAT, my lord. They can file a review application or miscellaneous application and seek a modification of this order. Let the CAT decide, my lord. How can an appeal be filed, my lord? Well settled, my lord. This kind of situation, my lord, where the order of the court is sacrosanct, my lord. We can't go behind the order of the court. The court is recording their submission. It is to presume that it is correctly recorded. If there is a problem, they have to apply before the same court. Otherwise, my lord, maybe in this case, my lord, there is no. I'm not suggesting anything, but my lord, in every case, my lord, after making a
I understand. Tell us, in the event the court thinks of any expert body, who can it be?
The CAT, I don't know, my lord. My learned senior had some suggestion. Maybe that can be made, my lord, before the CAT. I'm personally not aware, my lord, because it is very difficult, my lord, to constitute an expert committee. It happens in certain matters, like in that road matter.
My prayer it is there, my lord. I said, independent expert body. I am
Yes, yes.
asking for a committee.
Whatever, a body, whoever, a principal of the college, pharmacy college or something.
Everybody is part of the administration here.
In that case, my lord, it was sent to Delhi and from there the
Those suggestions should be made before the tribunal.
My lord, page 78. I have shot for an interim order. My lord,
78.
Page number 78. It is not that. That's why I have fairly submitted before this court. This order, and page 78, there was an interim order placed before the tribunal. It is not that I have filed an application when the court was about to pass an order. I said that it can be disposed of. My specific prayer was for an interim order, and I was arguing for an interim order. And in my application before this court, I have specifically stated, my lord, that the matter was heard on 12th of November 2011, and the order was uploaded on 27th of. My lord, may kindly see page 18, paragraph number 29 of my instant writ petition. I have specifically stated the copy of the said order there was uploaded in the website on 27/11/2024. It is not that the order was passed on 12th itself.
But my lord, that cannot.
Is the order passed orally in court, open court?
No, my lord, order, because my lord, this was.
It is mentioned over here, oral order. Page 5010, order oral. It's not passed in open court. The hearing took place on
The matter,
the 12th.
the matter held for a considerable period, my lord, through virtual mode,
Yes.
and thereafter, my lord, this order was.
The date of the order is 12th of November.
My lord, yeah, that is what, my lord, when the matter was heard, subsequently the order comes. Even judgment, in one case, my lord, I was arguing before my lord Justice Bindal and my lord Justice Haridip Banerjee. The judgment came after 8 months.
That is different. Judgment is reserved. It is passed later on is different. Here it's mentioned oral order. We just wanted to know whether the order is passed in court, open court.
Usually, interim order is passed in court. But
Otherwise,
My
this,
lord, it was disposed of, my lord.
yes, so it was in the chamber and you didn't get to know what is exactly recorded.
I never submitted this, my lord. My submission was confined to that interim order because unless and until the other side either file an opposition, because my lord, if my lord sees in the light of the para 9, they categorically said whatever we can do, we have done it. After that, what is the use of relegating the matter before the authority? Because para 9, my lord, only see.
I am not disputing what is being submitted.
I have followed, but then paragraph 11,
My lord.
the way it has been couched, it appears that
And in that case, my lord may.
as per your
protect my
submission,
right. No, my lord.
your right is protected.
No, my right is protected till disposal of the my represent
That has not been disposed of. Your
Not-
representation is there. So
for the time.
has it been done?
No, it was not done.
Approach the court immediately. The order you say was uploaded on the 27th. You still have some time. Why don't you approach
But
the,
in such period, my lord, my application is taken off mine because 2 weeks time.
you are yet to file the application. How can the court say when you will?
We appreciate the situation. The interim order was granted after 2 weeks. Now, my lord, can we visualize this situation? It will delay. After all, if this person or any other person who have to get it, once the issue is clear from the expert body, everything will be clear.
Expert body has to be constituted. Your submission as it is recorded is that if your representation is considered by the authority, it's all right. Had it been by the expert body, only if this word is replaced and a body is constituted, then your purpose is solved.
The objection of my
No,
other friend.
then I just said something.
This will be the
Yeah, no,
submission.
Here itself, my submission is my lord. I think now not as a concession, but as an officer of the court, I'm submitting. My lord, in that case, my lord may grant them a week's time. And until that, for that period of 1 week, my lord may extend the say the interim order is extended. That can be done, my lord.
If you can come up with any suggestion, you too also,
My lord.
as to who can be engaged as expert, then we can take care of it
My lord.
here and now.
My full submission is my lord may not do so, my lord, because it will set a precedent, my lord. Then order, my lord, is recorded, my lord. Order of court is sacrosanct, my lord. Then my lord is effectively, if I'm not saying he can always, my lord can protect it for a week.
That's
Not nothing back, my lord. Justice has to be seem to be done, my lord. He can't. My humble submission is, my lord, let them be protected for a week. No difficulty. Let them move the application before CAT. Not till an expert body is constituted. My lords will.
No, that the court will decide.
That question, but
It
one
is matter of-
granted
Whether
protection,
part
my
will give book or not.
In that case, my lord, my prayer would be, I would be filing the application within a week. Let the tribunal be directed, because from next week also, tribunal is there. Directed to dispose of within 2 weeks. And until, till such time, my right may be protected and may be allowed to renew my prayer before the tribunal.
That my lord can pass. my lord.
That would serve their purpose.
The petitioners are aggrieved by the order dated 12th November 2024, passed by the Learned Central Administrative Tribunal, Kolkata bench at Kolkata. Stop paragraph. The matter relates to a selection process of pharmacists. Stop. Raising certain issue with the with the examination which was conducted, the petitioners approached the learned Central Administrative Tribunal. Stop. After hearing the parties, the tribunal records that within quotes, during the course of hearing, the learned counsel for the applicants submitted that it would suffice his purpose if the authorities be directed to consider the representations of the applicants in its true letter and spirit, which they had submitted before the authorities, treating the OA as part of it and communicate the action taken, if any, by answering their grievance within a stipulated period of time. And in the interim, the said select list may not be given effect to till the communication of their reply. Paragraph. The petitioners have averred in the writ petition that though the order was passed, though the hearing before the tribunal took place on 12th November 2024, but the order was actually uploaded on 27th of November 2024. Stop. It is from the, it is after the order was uploaded that the applicants got to know that the submission made by the learned counsel for the applicants was not correctly recorded. Stop. The petitioners herein never prayed for a direction upon the authorities to consider the representation, as the respondent authority already considered their prayer and passed order.
Allegedly considered.
Allegedly considered their prayer and passed order. So, prayer before the court is to engage an expert to look into the error in the question paper. Stop. Paragraph. Learned senior counsel representing the administration opposes the prayer of the petitioners. Stop. It has been submitted that as the learned advocate representing the petitioners mention about wrong recording of the submission made on behalf of the applicants. Accordingly, the same ought to be brought to the notice of the learned tribunal. Stop. Paragraph. Upon hearing the parties, it appears that the applicants seek for an expert who can verify the questions that were put in the examination, which according to the petitioners were out of the syllabus, and there were certain wrong answers mentioned in the answer key. Stop. Paragraph. The once the authorities have already disclosed their stand, accordingly, remanding the matter back to them all over again for reconsideration may not serve its purpose. Stop. Paragraph. In view of the above, the petitioners are granted leave to approach the tribunal with their prayer within 1 week from date. Stop. In the event such an application is filed, the tribunal is requested to consider the same, to consider and dispose of the same at the earliest, but preferably, no, at the earliest, stop it. Till a Till any order is passed by the learned tribunal in the application filed by the application to be filed by the petitioners, comma, the select list published by the authority shall not be given effect to. The writ petition stands disposed of. This is the best.
Yes.
This is the best that could have been done in such a situation.
I come from PRA 4, 124 with carry.
State lordship. Lordship, I am for the appellate lordship. It is a statutory appeal, appeal against conviction of business inspector of 10 years and fine of 5,000 rupees. Lordship, I pray that the registry may be directed to prepare the required number of papers. There is section 5 also, Lordship.
How many days delay?
Lordship, 1,755 days.
1,007.
755.
Because Lordship,
What?
Lordship,
Lordship, it
in
is,
respect of section 5 application, I may be allowed to file
Lordship,
objection, Lordship.
Lordship,
Where is the section 5?
on the occasion of jail clinic lordship, I went to the jail and wherein I could meet this appellant. And after that, he told me the case. I said, I have come before this honorable. Kindly appreciate he was not knowing about.
He is in jail now.
Also, in connection to another case.
In-
And lordship kindly
In
appreciate
another
this
case also.
In this case, lordship,
He
the
might
victim girl,
prefer
the victim
appeal.
girl happens to be his wife.
Jail, appeal from jail. He might prefer.
Lordship,
There is
no, I am
prefer.
just briefing the fact. Another case that is pending at Port Blair.
Against the same person?
Same person actually
Actually, the same
victim
victim girl. Victim girl happens to be his wife.
actually used to reside as a husband and wife. First pregnancy,
Yes, sir.
child born, second on pregnancy, reported by the doctor, case registered.
First
Then
pregnancy, child born.
it
second
was
also case,
first case conviction
second,
given.
second child born. Happens to
Also?
one daughter and one
Not
son.
guilty. What is the age of victim?
Now,
At that minor, now major.
Now minor.
Now, met.
Yes.
At that time she was.
She was
Minor.
she was fine. She's the appellant has already in custody for 5 years. Around.
What is what is your sentence?
10 years.
10 years.
10 years.
So she paid about 47%. 47.
Wrong of his right to defer an appeal against the judgment. Everything was, and even when we did not, it is, it's instance, this is.
Section 3 WCP 2 of 2024.
I intend to implementation of 25 ACRPC, that is the establishment of title prosecution by the state. As per 25A, the state government may establish a director of prosecution consisting of a director of prosecution and as many as deputy director of prosecution as it deems fit. I am on that.
Public investigation.
They state
Page
issue.
10.
Yes. There must be the directorate of education. Then
This is he
what
wants
is the
implementation.
system? What the system is running?
System is there. The state may establish a director of prosecution for handling the criminal cases
Oh,
from the
nahi
lower
hai.
court to high court.
Here in Anwar.
What?
The directorate of prosecution is here.
Note there,
Opposition.
I have come
Oh.
for the establishment
बोल दे.
for the implementation of this section.
What
All
is
the
this?
pertaining-
We have
State.
filed our opposition by lord, but I think it is not on record, my lord. Their reply is on record.
What is this?
Steps are being taken, but this is not a mandatory provision. The word may is used both in 25A and 20 of BNSS, which is the
Yes.
new statute. So steps are being taken, my lord. I doubt whether he can file a writ petition, my lord. There is no.
You all are taking steps.
Steps are
And how
being
soon
taken.
will it be implemented?
There's several, my lord, because the union territory, my lord, several approvals, etc. are required from the center.
Whatever, if you all are taking steps, it must culminate to a final order or something, a decision to be taken.
Steps are being taken, my lord, but my lord, it's difficult, my lord, to,
You file a status report with regard to the steps taken.
he'll do that.
This is the pure matter of administrative decision. So,
The administration will take steps. The instant public interest litigation has been filed, praying for issuance of necessary direction upon the administration for establishment of the Directorate of Prosecution. So, paragraph, learned senior counsel representing the administration submits upon instruction that the said provision is not a mandatory one. Stop. However, the administration is taking steps to establish the Directorate of Prosecution. Stop. The administration is directed to file a status report with regard status report disclosing the steps taken to establish the Directorate of Prosecution. When will you file it?
At least 2 weeks, my lord, may be granted.
By 30th of December?
affidavit of opposition.
By opposition, we'll find the status. With a let a copy of the same be served upon the petitioner. List in the next circuit.
I do advise.
Well,
Opposition is already been granted.
You must bring time for.
No, opposition is fine, it's not an.
Oh, yes, yes. Not.
Item 4, PRA DB3 of 2024 with trial 2 of 2024.
I have seen Madam Chair, Mr. W is appearing for the respondent and paying for doctor.
So I for the state appeal against acquittal under POC. So special leave to appeal is pending. Section 5 already allowed. Against that special leave application, they have to respondent has to file leave. Order has been passed long for filing leave.
When the AO will be filed?
The senior is not in station.
We are extending the time. Please come. The affidavit in opposition to be filed by the respondent has not been filed till date. On the prayer of the learned advocate representing the respondent, time to file the affidavit in opposition is extended till 30th of December 2024. List, reply, if any, may be filed prior to the next date of hearing. List in the next available circuit.
Blair.
नहीं नहीं तब बस
What is grant 2? Has that been discussed already?
तो होगा नहीं.
Then why is it shown till now? Oh, this is grant 3. Grant 2. Yes, then grant 2 order, if grant 2 order has been passed, then that has to be disposed of. Why will it remain pending? No, if there is grant 1, grant 2, then need to prefer appeal. Let me see what is the prayer in the grant. Leave has already been granted, then the grant needs to be disposed.
Grant 1 and 2 has been discussed. What is grant 3?
This is grant 2. There is no grant 3.
Grant,
In C only 3.
where is grant?
No, there is no grant 3.
Then wrong recording.
No, it's grant 2.
Oh, yeah. Then grant 2 has already been.
Grant 2 is pending. Very.
No, not pending.
How can it be pending? This is what I'm thinking.
See the order dated 30th August 2000, grant 2. Application for leave to.
Leave has already been allowed, isn't it? Leave has not been allowed.
Shall be given an opportunity.
Oh, in the leave it has been, very well. In the leave, they have been,
Application complete to open before.
yes.
Subject.
Subject.
Yes. Not.
Item 5, WPCT 19 of 2024. Fire in this case, ballot machine appearing for the petition. I still time to file agreement reply. To which time?
On the prayer of the learned advocate representing the petitioner, time to file the affidavit in reply is extended till 30th of December. Stop list in the next available circuit.
Item 6, WPCT 28 of 2024.
My lord, I have served. We have served, but my lord, affidavit of service is required. It has been delivered also, but affidavit of service has to be filed, my.
Nobody is appearing.
No, my lord. The file affidavit of service, my lord. Let it come after that.
Come up when?
Whenever your lordships, my lord. Next circuit or even next week, whatever your lordship.
Where does the original applicant state? Import Blair only. None appears on behalf of
Andaman zone.
respondents. Stop. Affidavit of service is not on record. Stop. Let further notice be issued upon the respondents intimating that the matter will appear in the next available circuit. Affidavit of service shall be filed on the adjourned date.
Some 7, Night 29 of 2024. With tab on and guide.
Yes, paperwork is to be filed. All the copy over. As I'm filing the paperwork, copy has already been served, my lord, on the other side.
What are the cans for? Can 1 and 2?
They filed the appeal. In the meanwhile, one of the writ petitioner died. So I have
Alright.
taken out an appeal. to-
For substitution.
That has been allowed.
That has been allowed. It is still showing in the list.
That allowed. That was it.
That is can 1. What about can 2?
Can two my lord will be for stay.
Application for stay.
Substitution, can one will be for stay.
Both the cans have been disposed of. Has
Okay.
substitution been made? You say it has been done.
Substitution.
Substitution was allowed.
Application for substitution. Can 3 is disposed. Condonation of delay is can 3.
Yes, ma'am.
Can 2 is application for substitution is disposed. Can 1 appeal and stay? The appeal is to be heard. All 3 cans appear to have been disposed of. But then it should not be there.
Can one is still pending.
No, it cannot remain pending. Can 1 appeal and stay? Stay has been granted. Isn't it? If paper books are filed, then what remains in the can? So now it has to be heard.
Tomorrow,
Tomorrow, Friday. No,
Monday.
Monday we fixed up a lot of
Tuesday,
matters. Yes, in that case, please.
Why not today? But
No,
You can-
Monday.
This is a,
There of
yes. If you want, you can start today also.
I'm ready, but if my learned
No,
senior
you-
wants Tuesday, it
They
is
start-
okay.
I will apply.
It's for you.
Well, I'm ready, but it can come next week also, no.
Wait. Paper books have already been filed. Stop. List the matter for hearing on 10th.
Item 8, WBCT 34 of 2024. Application and disputes, signing the affidavit service.
I'm appearing.
Who
The
has been
private
refused?
respondent,
Private.
private respondent.
Refused?
Did.
Did the private respondent enter appearance in the writ? In the original application?
There also is in appearance.
It appears.
But original application was rejected, so therefore my lord, appearance may be necessary.
Several attempts were made earlier also, on two occasions I served here also. The same result has come here also, he refused to accept it.
What is your prayer?
I am challenging the appointment of the private respondent. Doctor, these are not the I will serve again. Next week, we will instruct the doctor. He is being put it in garage and must be nearby.
Here only. Please come. The instant writ petition has been filed, challenging the order passed by the learned tribunal, wherein the appointment of the private respondent was under challenge. Stop. The presence of the private respondent will be required for the effective adjudication of the instant writ petition. Stop. Paragraph affidavit of service has been filed, annexing the copy of the writ petition, which was sought to be served upon the private respondent, but has come back with the postal endorsement refused. So, accordingly, under which police station will it fall? The,
Yes, pardon. Yes, pardon.
you know what it is? Private respondent's address. The officer in charge of such and such police station is directed to serve a notice on the private respondent, intimating that the instant writ petition will appear in the list on 12th December 2024. Stop. In the event the private respondent remains unrepresented, the writ petition will be decided ex parte in his absence. Please come 1 minute. Learned advocate for the petitioner is permitted to take back the unserved writ petition by unserved writ petition, but the envelope with the postal endorsement refused shall be retained in the records. This petition he'll take back, but this envelope will remain, right? Yes, the original envelope will remain because there is the sign refused. This will remain, but the writ he'll take back.
तब तक के लिए protect किया जाए, तो already protected कर सकते हैं
You take back the writ so that you can give it to it, serve it upon him. No further photocopies to be made.
Item 9 at 41 of 2024.
My lord, this matter, my lord, may I just explain the issue, my lord? The issue is, my lord, a learned single judge passed an order under section 17B of the Industrial Disputes Act, saying that because they had succeeded before the labor court, to say that pending your challenge, you have to pay them as per the law, what is required to be paid. So affidavits were called for regard to ascertain the status of their employment, and then this direction was passed. But the order of the labor court itself was in challenge before the division bench. Eventually, the division bench has set aside the order of the single judge, sorry. Single judge has set aside the order of the labor court. But that order under 17B was independently challenged during the pendency of the appeal against the original order before the division bench. So now today the situation is that the order of the labor court has been set aside. But this appeal is pending. Now, the contention raised by the other side is that they are saying that even if you succeed in the appeal and the original order is set aside, that direction to make deposit under 17B is an independent direction. So that is a legal question, my lord. So I seek some time. No, I need to, my lord,
Get yourself
examine this question, my lord. Let it come, let it be Tuesday.
Because that is the law, my lord. 17B is independent. Statutory, it says if a person succeeds before the labor court and an appeal is preferred by the state authority, for the intervening period, he is entitled for the last page which he has drawn. And on that score, there are several judgments. It's a settled proposition of law. So my learned friend, on two occasions, both the court said nothing doing, you have to make payment. Then
I'll have to examine, my lord.
let it be on.
Let it be on.
Last three circuit, my learned friend is examining, my lord. So
Let it come on Tuesday, my lord. No.
Very well. On the prayer of the learned advocate representing the appellant, list the matter on Tuesday, 10th.
My lord.
Item 10 at 47 of 2024.
Adjourned. Two, all right. 10. On the prayer of the learned advocate, on the prayer made on behalf of the learned advocate representing the appellant. Come on, list the matter on 9th. 10 seal. No, it's 10 and 11. 10 and 11, same order. It will appear on the 9th.
Item 12 at 54 of 2024.
Lord, I am appearing for the municipal council.
Item number 12 and 13. On behalf of advocate Arun Prashant, I am submitting lordship their matter is posted next meeting.
Lord, it is no issue, Lord.
There was an order earlier that so far as the respondent is concerned, for which Mr. Ravi Kumar appears, there is an order of this honorable court directing the courtier who is counsel to take action against him. What action they have taken that is to be.
Lord, we have initiated. Lord, during the pendency of the appeal, the honorable court, they have filed a complaint against the private respondent, saying that the private respondent is building also illegal building. So we have issued show cause and they have filed reply to show cause. There was
Allegation, counter allegation against unauthorized construction.
now hearing, no, my lord, let me, my lord, hearing notice was issued and it was fixed on 20th, 21, 22. But my lord, 21, 22, it was not to be, hearing could not be taken up, my lord, due to administrative reasons. I requested the time till 20th, my lord, all matter is fixed on 16th, my lord. My lord is fixed, passing actually. Lord, there is a demolition. This court has passed an order for demolition because he himself submitted that he will demolish unauthorized portion. Lord, we are not saying anything. Lord, we will, because the court says hearing has to be given to him in terms of the rules. So we have already issued a notice. My lord, I file an extension application.
My client is concerned when.
Lord, in that,
Another client is-
Lord, if after hearing, if it is found that it is an illegal building, we will demolish, my lord. That may be recorded in the order.
There is no plan at all.
They are producing a.
Please come. An accommodation has been sought for on behalf of the learned advocate representing the private respondent. So, the
Lord, I file an application
The-
for extension of time.
directed the municipal council to take steps against the unauthorized construction of the private respondent and to file a compliance report before this court. Stop. The matter is adjourned till the next circuit. Stop. The municipal council shall file a compliance report before the court on the adjourned date with advance copy to the learned advocates representing the respective parties.
Very surprising, your lordship.
Lord, I filed a can of.
Notice, which is annexed with page number 20. The notice is issued on 22nd November 2024, fixing the date after a month, 16th December.
My lord,
So,
the second. No, my lord, the secretary is.
Conduct of the other side.
My lord, kindly see page number 18, my lord. The secretary is not in station, my lord. That's why he is returning on 15th and we fix it on 16th. My lord, last 3 consecutive days, the matter was fixed for hearing. My lord, the can I have filed for extension of till 20th, my lord, that may be disposed of, my lord. Because already I filed a can application for extension of time.
Where is the can?
My lord, it should be can, I think, suppose one in MAT 54 of 2024.
Yes, can.
MAT 54. Extension of time. Extension of time. Extension of. ಇಲ್ಲ ಇದೆಲ್ಲ ನಾವು order.
Staying the
Extension of time.
demolition order. But the demolition order has already been implemented, isn't it?
With regard to the implement, it has been implemented.
Sorry.
But then the other side, was any order passed?
Yes.
No.
This order.
No, I clarify, my
This
lord.
order Pass the order that you have to initiate proceedings and order has to be passed. That order was passed long before. From that day, they are just issuing notice one after another to you. That's it.
My lord, the date was fixed on 14th November.
No, you mentioned that we've heard, but then, interim order you sought for the,
I just
Stay of
prayed for
the-
an extension of time, my lord, till 20th, so that the proceedings will be concluded and order will be passed, my lord. After giving opportunity of hearing to the
the council.
private respondent here.
Time to comply the order passed by the learned court on 9th August 2024 is extended till
Lord, it is 12/11, my lord, not 9. 12/11 order, my lord. Division bench is passed in 12/11 order.
12th of
12th November, order was.
Order was passed.
the 12th.
Secretary.
12th November is extended till 20th of December 2024. Stop. The connected application CAN 1 2024 stands disposed of.
Problem. अनुपम में दिया
This matter is ready for hearing. Stay for information in next Monday.
Oh, Monday, what is the urgency?
Agency the petitioner applied for a loan before authorities may not sit the concern or can sort for notice non-items. Because denied my plan of getting a document from any of them.
What has that got to do with the appeal?
Authorities are directed to file the affidavit in opposition within 10 days. Well, the time has been lapsed. This was not listed as a cause, paying for listing this matter before.
Opposition has not been filed.
Fine, 10 days time has been given.
Expired. Very well, to be mentioned. Give notice to the other side.
Yes, yes.
To be mentioned, Monday.
I'm great to mention.
Item number on.
My lords, in this matter, my lord, I have objection to the maintainability of the writ petition, my lord, because there is a
Here,
disputed question and arbitration clause is also there.
now, my lord,
So, my lord,
a work was undertaken. If work was undertaken, I am a class 1 contractor, a work was undertaken, work was completed, work completion certificate was issued. My lord, may kindly come to page 32, work completion certificate.
Yes.
Now, my lord, work completion certificate was issued, payment was made, but escalation amount was not paid. My lord, may kindly come to page 27. The escalation with regard to labor, material and all, my lord. I have claimed, page 27. 23rd February 2023, the total amount which I have claimed is 84 lakh. Now, my lord, after deliberation, my lord, thereafter the amount, if my lord sees next page, page 28, 8 March 2024, my lord, actually. 29 would be relevant. The amount is, it cuts down to 65 lakh 96,000. Now, my lord, this is the amount which I have, rest of the payments were made. Now, my lord, may kindly come to their own letter at page 33, dated 23rd September 2024.
Yes.
They have written this letter to my client. Now, my lord, may kindly see, with reference to your cited subject, the revised estimate has also already been submitted to the client department. Client department and is under scrutiny at their end. As per the office order dated so and so, the explanation amount derived was so and so. However, your firm has worked out the same as 84 lakh and revised to so and so, which needs to be confirmed, for which correspondence has been made by this office. However, to avoid any future complication by way of further revision, the amount as claimed has been projected in the revised estimate. This office had cleared the final bill for the project work by making payment up to 10% of administrative approval and expenditure sanction. However, the explanation could not be fully paid into the revised on account of amount beyond permissible allowed variation of so and so. The actual payment for balance explanation after consideration due to difference between work out amount by this office and your claim shall be made on obtaining the revised sanction from client department. The necessary steps to be initiated by this office has already been made, and client department is also processing the case for revised sanction. This office has made payment of final bill in time and taken all steps to ensure that payment are to be made as per the applicable rule in time, to the extent that funds are made available. You are requested to kindly await the revised sanction from client department. So, my lord, in terms of this letter, they have to act. Nothing is disputed.
This is in September.
September.
After September, nothing took
Nothing.
place.
Now, my lord, this I have raised the claim in 2023 February. Thereafter, that revised was submitted.
Yes, I followed. You
No
have
dispute.
practically admitted it.
so my lord, the quantum is disputed, my lord,
Very
because
well.
10, then we'll file affidavit.
Quantum, you are awaiting the revised sanction,
Yes.
obtain it and make
Then
payment.
we'll file affidavit, my lord.
No,
No, because my lord, there'll be dispute regarding the, no, then,
very
no,
well.
I'm not talking about arbitration, but let me file.
50, 505281 you admit. Third line of page 33.
Yes, yes, yes.
The escalation amount derived was 50, 52, 831. Did you get
Right
that
there.
figure?
As
Page
per the
33.
20th November, 28th,
23rd September 2020, page 33.
yes,
The last page, see third line from the top.
And
Yes,
my lord,
sir.
this was done on 28th of November 2023.
28th of November
24.
2023, you have worked out till 50 lakh.
Yes,
And
ma'am.
his claim is 65. So there is a difference of around 15, 14 lakh or 15 lakh, not more than that.
No, but we have also paid, payments have been made even after this.
No, no, no.
10%, 10%.
10% my learned is not aware. 10% is that administrative approval and expenditure sanction. If it is more within 10%, it is within their domain.
No, my instructions are, my lord, that they have cleared the bill up to 10% of administrative approval and expenditure sanction.
Yes, now the little bit that is left, you are awaiting sanction. Why don't you obtain a sanction and pay off what is admitted? With regard to the disputed portion, he may prefer
Then
suit,
my lord-
he may do whatever he feels
My
like.
lord may
But what about
dispose
the
it of, my lord.
thinking of disposing it of?
My lord may dispose of, my lord, but my lord may, only difficulty is, my lord, affidavit has not been filed, so my lord,
It is not a matter of your filing affidavit, page 33 is there. On the basis of page 33, it will be disposed of. Nothing, no concession, nothing
My
of
lord.
this sort.
My
Please
lord.
come. The petitioner is a contractor. Stop. Certain work was done by the petitioner in accordance with the work order issued by the administration.
Only thing,
Stop.
my lord, my submission that there is an arbitration clause may be recorded because.
I will.
Right.
Stop. The payment as per the bill raised by the petitioner has been cleared. Stop. The amount on account of escalation where do I get that? Page 27.
Page 27.
On account of what is exactly the term used?
Escalation, my lord. Escalation
account
for,
of-
my lord, labor, material and POL.
Exclamation,
Lubricants.
escalation for labor, material and
And petroleum, lubricants and oil. These three things.
petroleum, oil and
In
lubricant
short, it is fuel.
Is remaining pending. Stop. From a communication made by the executive engineer, construction division, number -III APWD Protharapur,
Respondent number 5.
the respondent number 5, dated 23rd of September 2024, it appears that the prayer of the petitioner for payment of the amount on account of escalation was scrutinized by the department. Stop. The escalation amount derived by the office on 28th of November 2023 was rupees 50,52,831. Stop. The petitioner appears to have revised its bill and the bill before the authority, that is pending, amounts to rupees 65,96,981. Stop. Paragraph. The office has cleared the final bill for the project by making payment up to 10% of the AA, what is this? Administrative approval and establishment sanction.
Expenditure.
Oh, expenditure sanction. Stop. However, the escalation could not be fully paid due to the revision on account of the amount beyond the permissible allowed variation of A/A and E/S. Stop. The communication dated 23rd September 2024 further mentions that necessary steps are being initiated by the office for processing the case for revised sanction. The petitioner has been requested to wait till the revised sanction from the department is received. Stop paragraph. Prayer has been made to direct the authority to clear the final bill. Paragraph. Learned senior counsel representing the respondent authorities raises an objection with regard to the maintainability of the writ petition. Stop. It has been submitted that there is a provision for arbitration in the agreement entered in between the parties. Stop. The petitioner ought to be relegated before the arbitrator. Stop. Paragraph. Upon hearing the parties and upon perusal of the materials on record, it appears that the prayer of the petitioner for payment of the escalation amount was duly considered and scrutinized. Stop. The amount sought for by the petitioner on account of escalation has been disputed. Stop. The office letter number 3046 dated 28 November 2023 mentions that the escalation amount derived by the office was rupees 50,52,831. Stop paragraph. The authority appears to have admitted the maximum portion of the petitioner's claim on account of escalation. Stop. In such a situation, relegating the matter for arbitration will not serve any purpose. Stop. Paragraph. In view of the above, the instant writ petition is disposed of by directing the who will give the sanction? Chief engineer or what?
There, because they say their client department is IRBM. I
All
am
right.
concerned with respondent number 5 because
So very well. The respondent number 5 is directed to take necessary steps for payment of the amount claimed by the petitioner on account of escalation after verification of the records. Stop. The admitted amount of rupees 50,52,831 may be released at the earliest. As regards the balance between the admitted amount and the amount claimed by the petitioner, that is rupees 65,96,918, shall be paid after obtaining the necessary sanction. Stop. The concerned authorities shall obtain the necessary sanction so that the payment of the petitioner is made at the earliest. Stop. The respondent number 5 shall ensure that all payment is cleared within a period of 8 weeks from the date of communication of this order. Disposed.
for interest, because my lord has seen 45 November 2023, this amount is lying.
My lord, in that case, my lord.
1 minute, 1 minute.
For interest. then I have to
Have you made a prayer for interest?
pay 16.
Then my lord, may we have to further.
Acha. As the petitioner would receive the amount that was payable to him after a considerable delay. Accordingly, the authority shall consider the petitioner's prayer for grant of interest on account of the delayed payment. Stop.
Instead of 1 corner, tender.
After the tender, a work order must have been issued.
No, tender agreement was.
Acha. Work order in place of work order, tender agreement. Who is your other side? Opposition. Service. What is your prayer?
Owner of a piece of land. During his lifetime, he has executed a will in my favor. I exercised that will before the Tehsildar. Tehsildar has passed a recent order and the land property was recorded in my name. And it remained for a considerable period in my name. Then my client sought a demarcation. So when he was asking for a demarcation, they were not conducting demarcation. So I approached before this honorable court and there was a direction given out to them to correct the records. Why? Because name of the petitioner hearing and another private one person named Mukesh Lal was also there in the record of rates. So I was surprised to see my property how it has been recorded in Mukesh Lal's name. So I made a representation to the Tehsildar seeking for a correction. That I came before this honorable court, the honorable court directed them within a time period they have to correct this. While passing the order, they said that your name has wrongly been recorded, so they're stuck off my name. That order is.
And the challenge. Page. You are there? Yes. Yes, 18th of September 2020. Yes.
Last para page 25. Now therefore, after careful circumspection of the case, I am of the conceded opinion that the land in question disposed of by Rama Rao, son of late Govind Rao, that is the original allotment, in favor of Sri Mukesh Lal, son of late Kanhaiya Lal, on the strength of registered sale deed presently recorded in favor of Sri Mukesh Lal, son of late Kanhaiya Lal. Hence, the entry made in the record of right in favor of Sri Raja Padmakar Rao, son of Ishwar Rao, with respect to the land bearing survey number such and such, held in area such and such, situated at Stockton Unit, is required to be struck down and also to be deleted from the computerized land records available in website, following the spirit of revenue records as maintained by the area of government. My name is Suresh. For this reason, his name was struck down. Now my name was entered to purchase land by Mr. Mukesh Lal on the strength of a registered sale. They are completely silent that why my name was struck down and his name was entered. Because I never executed any sale deed in his favor.
No, but then your seller executed the sale deed in favor of that person.
They have entered my name. There was a detailed proceedings. It is not there. And this man, Mukesh Lal never came before the Tehsildar. He never came before this honorable court. I don't know who is he. And they have not supplied me the copy of the sale deed what they are relying. No such copy was supplied to me.
Can you not obtain a copy from the registry office over here?
Supplied after the order was passed.
How can the authority look into all these things? Because these are all disputed questions of facts.
These are the disputed questions. This man should exist. This man is not there in existence.
You obtain an order from the civil court that the land belongs to you. You are the owner of the land, a declaratory suit, and then you can get your name corrected. Over here, it cannot be done. Please come. The order dated 18 September 2024, passed by the Tehsildar, Port Blair, by deleting the name of the petitioner from the land records, relying on a deed of sale allegedly executed by the recorded owner in favor of one Shri Mukesh Lal is impugned in the instant writ petition, LALL. Stop paragraph. The person in whose favor the land has been recorded has not been impleaded as party in the instant writ petition. Stop paragraph. According to the petitioner, the subject land was recorded in his favor, relying on a registered will and mutation was also made in his favor upon payment of mutation fee vide RC number 2108/TPB/2012. Stop paragraph. The petitioner contends that after such a long period of time, the authority ought not to have deleted his name from the land records. Paragraph. Learned advocate representing the respondents submits that the name of the petitioner stood deleted as a registered deed of sale was found to have been executed by the recorded owner in favor of the aforesaid Shri Mukesh Lal. Stop. Paragraph. Upon hearing the parties and on perusal of the materials on record, it appears that an issue has been raised with regard to the ownership of the subject property. Stop. The Tehsildar is not the competent authority to decide ownership of any land. Stop. It will be open for the petitioner to approach the competent civil court for declaration of ownership right. Stop. If the petitioner succeeds to obtain an order declaring him to be the owner of the subject land, then the Tehsildar will be bound to take necessary steps in accordance with the order passed by the civil court. Stop. There is hardly any scope for the writ court to enter into and decide the instant issue. The writ petition accordingly stands disposed of.
Item number 3. WPS 672 of 2024.
Yes.
Hearing for the state cooperative society. There are 3 of the responses can be given. Copy of the petition was served, my lord. This is Lord, I am seeking for an interim order, my lord.
1 minute, 1 minute. The Registrar Cooperative Society, Central Cooperative Welfare Society. You will not be representing 2.
No, private respondent.
2 and 3 he cannot.
Filing an affidavit of service tomorrow so that the matter can be taken, because I am seeking for an interim order.
What is
Service not affected.
what is the interim order that you are seeking?
Interim order, my lord. This is facts, my lord.
Tell me the interim order just
A notice was published and
By?
stay of the society.
so 2 and 3 are the answering respondents.
2 and 3 are the answering respondent. Even the respondent number 1 is having the pervasive control.
Show me that notice which you want stay of.
My lord, at page 52, my lord.
Yes.
The annual general.
Meeting of the Cooperative Society will be held on 29th.
So, clause 6 is the election to the managing committee member.
Yes.
Here they have not updated the membership. Earlier, my lord, this issue came up before this honorable court during the earlier election. There, my lord, the writ court passed certain direction. I being agreed, I challenged it before the division bench. My lord, division bench passed an order. My lord, that was confined to the election only, my lord. Now, thereafter, they are not allowing them to update.
Very well, I get it. Yes, but then you can always see whether the list of the members are updated or not. Only this.
My
List also.
One minute.
understanding is two and three is an normal.
Yes, they are private parties, but then you being the registrar of the cooperative societies, you can always ensure that this is done. So that the election,
Let a copy be given and come back to court.
you don't have a copy also?
I have sent the copy, but-
Maybe his client has not forwarded it to the, please come. No, instead of tomorrow, you come back next week. The election is on the 29th. So time is there.
Yes, sir.
Next week you come back,
Yes.
let the registrar take instructions
I know.
from the authority, from the respondent number 2 and 3, as to whether they have updated or not, and you file a status report.
Just a moment.
The respondent,
Let my humble submission is, my lord, let it come on Monday.
all
I will
right.
Take instructions and this order which your lordship is indicating that may be passed on Monday. So I take my instructions.
The respondent numbers 2 and 3 are not represented. Stop. The petitioner seeks stay of the notice dated 28th of November 2024, issued by the Secretary of the Central Cooperative Welfare Society Limited. Whereby the elections have been declared on 29th December 2024. Stop paragraph. Specific allegation of the petitioner is that the committee is not updating the list of members of the cooperative society. Stop. Till an updated list is published, comma, it will not be proper to hold the election. Stop paragraph. Let further notice be issued upon the non-appearing respondents. Stop. Learned advocate representing the registrar of cooperative societies shall take necessary instruction. Stop. List on 10th instead of Monday, Tuesday. For holding the election. Date of election has been declared. The date of conducting meeting for holding the election.
Item number 4, WPA 315 of 2024.
My senior advocate, Ms. Anjali Nagapkar, on behalf of the petitioner, affidavit in opposition has been served upon us. I pray for some time to find the reply to this.
Very well. On the prayer of the learned advocate for the petitioners, time to file the affidavit in reply is extended till 30th of December 2024. Stop. List the matter in the next circuit.
All right.
Item number 5, WPA 645 of 2024.
The identical matter is 11th plus
11th. All right. An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. List the matter on 11th.
Item number 6, WPA 94 of 2020.
Order का copy. My lord, the division bench's order. My lord, initially this writs were dismissed, my lord. The item number 6 to 9 were dismissed. Then, my lord,
Remanded
the
back.
other side, this is the order passed by the division bench. My lord will see the ground of dismissal was res judicata. That these issues were already agitated and decided. However, my lord, the court has in appeal, my lord, the division bench said that is incorrect. And however, my lord, if my lord sees paragraph number 41 to 43,
Yes.
The other issue, my lord, that was raised on behalf of the respondent was the issue of maintainability, because my lord, this is a prayer is for regularization, and the correct remedy for that is to go before the labor court or central administrative tribunal. So my lord will see the findings. Paragraph 42, certain observations are made. However, my lord, at para 43, the court says, however, some laxity may be shown in favor of respondent authorities in this regard, since there was no opportunity for the respondents to prefer any appeal, as the impugned judgment of learned single judge in any event went in favor of the respondents. As such, we are of the opinion that the question of maintainability ought to be kept open for being adjudicated by the learned single judge on remand. So, my lord will see para 44. It is to be noted here that the judgment cited by respondent merits of the case have not been adverted to consciously, since neither this court nor the learned single judge, while passing the impugned judgment, have entered into the merits of the case. Insofar as L. Chandrakumar is concerned, since question of maintainability is left open, we desist from expressing any opinion on the matter. So, my lord, the issue of maintainability, my lord, in my humble submission, may be decided first, my lord. After that, my lord can hear the matter if my lord is of the view otherwise. Now, in all these matters, my lord, the admitted position is that the prayer is for regularization, and there is a scheme.
Regularization of whom?
Regularization of workers of workers of the forest department. Now, the prayer for regularization has been denied on the ground that they, on the merits, the scheme was in existence, but they were found to be ineligible under the scheme for different reasons. So, my lord, the first issue here is, my lord, there's a relief is for regularization. Secondly, there are disputed questions. So, my lord, in this light, my lord, I'm relying upon the decision of the full bench, my lord, of this honorable court. In the case of Avdesh Singh, kindly have, my lord, paragraph number 34 and 35. Kindly have paragraph number 34 first. We are of the opinion that when regularization, absorption, and or continuance in service continuance is sought, the Central Administrative Tribunal will have the jurisdiction as per provisions of Section 28 of the Act of 1985. The matter can also be filed before Industrial Tribunal or Labour Court, as the case may be. Section 28 does not oust jurisdiction of Central Administration, it gives option to the workman to choose the forum. Thus, High Court will have no jurisdiction to adjudicate upon the merits of the case, directing absorption, regularization, or reinstatement continuance in service of such employees with respect to affairs of controversies as contemplated within the purview of the Act of 1985. The cases have to be filed afresh before Central Administrative Tribunal or Industrial Tribunal or Labour Court at the option of the employees. So this is the references. References is accordingly answered. So
Where is the reference? Please show once.
my lord, the reference, my lord, will find at paragraph, the first paragraph may be seen. These writ petitions have been preferred by the petitioners directly before learned single judges of this court, seeking orders for their absorption, regularization as Group D employees of the Eastern Railway. A learned single judge of the court, by order dated such and such, referred 3 writ petitions to the larger bench, considering the conflict in 2 different division bench decisions in Eastern Railway versus Union and Lilwa Belur Cooperative Labor Contract and Construction Society versus Union of India. Another learned single judge, noticing the orders, has referred writ petition such and such for consideration larger bench. This bench has been constituted to resolve the conflict and for a decision on the preliminary issue as to whether these writ petitions are maintainable before the court of writ at the first instance. And my lord, even in L. Chandrakumar, my lord, I am not having the judgment right now, my lord, the Supreme Court has said that that at the first instance you have to approach the Central Administrative Tribunal. This similar issue had cropped up, my lord, recently before the division bench of this court. Here, my lord, various judgments, my lord, were cited on both sides. Now kindly see, my lord, paragraph 7. After hearing, and my lord will see paragraph 3 first. This the learned single judge had disposed of the writ petition in view of provision of section 14 of Administrative Tribunals Act and relying upon the judgment of L. Chandrakumar versus Union of India, held that this court lacks the jurisdiction to receive by and determine writ petition, therefore granting leave to the petitioner to approach the Central Administrative Tribunal. And then my lord will see appellant, that is a private party, at paragraph 6 had cited two judgments delivered by Allahabad High Court and judgment of Supreme Court in support of the contention as aforesaid, which is the contention is at para 4 that it is not an kindly see para 4. Appellant has challenged the said order on the ground that alternative remedy being not an absolute bar for entertaining a petition under 226, writ petition ought to be decided on merits. Then my lord, the division bench, paragraph 7. After hearing the parties and considering the judgment cited at the bar, we are unable to accept the contention of the appellant and also do not find any scope for interference with judgment and order imputed for the following reason. 1. The ordinary forum in case of disputes relating to service related issues of a person holding a civil post under union or state in view of the provisions of section 14 and 15 of the Administrative Tribunals Act 1985, read with provisions of section 28 and 3Q of the said act, is the administrative tribunal constituted under the said act. This position has been clarified in L. Chandrakumar by Constitution Bench of the Supreme Court. In the instant case, petition is admittedly holding a civil post. Ordinary forum is therefore the Central Administrative Tribunal for the petitioner to ventilate his grievance in respect of his service-related claims. Jurisdiction of the Administrative Tribunal again fell for consideration in All India Institute of Medical Sciences with Sanjeev Chaturvedi, wherein the Honorable Supreme Court, after considering L. Chandrakumar, has held that an administrative tribunal is even competent to hear issues relating to constitutional validity of any statute except Administrative Tribunals Act 1985, under which it has been constituted. The Honorable
Tell
Supreme
me one thing, can the post which the petitioner is single petitioner or not? I don't, there are many.
several petitions.
Very well, that they are holding can be taken to be a civil post?
Yes, my lord. All posts, my lord. There's so many matters where DRMs are approaching the tribunal or labor court. There is no issue whatsoever, my lord. That my learned senior will also not disagree.
One of my applications
Now-
was rejected by the tribunal on this head score. I approached the
No.
case of DRM before the tribunal.
No, further.
The
And
tribunal said he is not holding a civil post last week, my lord.
no,
And
the
there-
cat, and that is even otherwise, if we for a moment,
Are the petitioners?
that is only for.
Workmen are on.
I'll address that question, my lord. Now, first of all, my lord, there are scores of cases where DRMs, even in WPCT, my lord, is hearing where contractual workers have approached the cat. But be that as it may, my lord, that question of civil court is only relevant so far as Central Administrative Tribunal is concerned. Labor court option is always there. My lord heard
That
matters
is
even
there.
yesterday.
Yes.
So, my lord, kindly see para 4. The honorable and this the honorable full bench has said labor court or Central Administrative Tribunal. It's not.
L. Chandrakumar is regarding civil.
Yes, that is
Right.
cat. Even if we
Cat.
keep that aside for a moment. Now, kindly see after that matter, para 4, the Supreme Court in Roger Matthew versus South Indian Bank and has again clarified that jurisdictional high court can entertain a writ petition when the tribunal is inoperative or has not been constituted. Then, my lord, para 5, there is no dispute as to the proposition that alternative remedy is not an absolute bar for entertaining a writ petition. However, a writ petition can be entertained where the same is A, for enforcement of fundamental rights, B, there has been any violation of principles of natural justice, C, where the order under challenge is wholly without jurisdiction, or the vices of the statute is under challenge. Additional ground, my lord, it is noted that state of UP versus Ehsan, with an additional ground, party should not be relegated to avail alternative remedy where writ petition has been admitted and direction of affidavit. In the issue of alternative statutory remedy where there is a bar in entertaining a writ petition fell for consideration in Cellular Operators Association, the Honorable Supreme Court, after considering such and such, held the High Court will not entertain a petition under 226 if an effective alternative remedy is available to aggrieved person or the statute under which the action complained of has been taken contains a mechanism for redressal of grievances. Then, my lord, another judgment is cited. So, my lord, in this case, of course, in Administrative Tribunals Act was referred. And interestingly, in this case, as has been recorded by the Honorable Division Bench also when referring to the learned single judge's order, several of these parties have approached in the past. Maybe the division bench says that your res judicata does not apply because that was not the issue when you had approached earlier. But there is no dispute with the proposition that these people have already approached the administrative tribunal in the past. And today they have the approach of, they have the option of approaching the administrative tribunal or the labor court as they wish to. And the full bench, my lord, in Avdesh Singh says that for regularization, you have to either approach administrative tribunal or my lord, para 35 I had shown of this Singh's judgment. So they have the option of going to the CAT or to the labor court.
This thing, the employee was a Group D employee in the Eastern Railway.
Yes.
So for that, CAT is all right.
No, kindly see para 35.
I have seen that.
So it is not just CAT, my lord. Labor court option is also there.
In respect of this person.
That is yes, my lord.
Railway employee.
Yes, yes, that is right.
Yeah, but here he is.
But these the petitioners here, my lord, have already approached the Central Administrative Tribunal, my lord. It is recorded in the division bench's order also. If my lord, in fact, sees the order of the single judge, which was set aside by the division bench.
1 minute, 1 minute. Can you bring certain decisions that the post which the petitioner is holding is not a civil post?
That is not their case also. It can't be civil post. It is not a civil post. Apart from that, my lord, may recollect that yesterday I was arguing a matter whereby the labor code has passed an award whereby directed 1 by 30th of May, and so far as regular.
So this is what he's saying.
No.
You can approach the labor court.
No, they approached the labor code. In this case, already they approached. Yesterday case, they were also a party to that.
These petitioners.
These petitioners.
Then why are you here in the writ court?
Already labor code has passed an award. Matter went up to the Supreme Court. Now, once again, I cannot go to labor court. They are also the petitioner. My lord, may recollect 136 persons.
Yes, 136
136 persons. Now, what have happened, my lord? I am seeking discrimination. Out of that 136, 122 are given regular employment. They were not given regular employment.
But then in this case, I think labor court will be the
appropriate award is there.
Award is there for payment of 1 by 30.
Regularization part is also there.
Very well. If the order is not complied with, then you have to.
No, this is not. No, 1 second. I'm sorry, my lord. The award is in respect of X number of persons, 136 people. Their contention is that the same benefit should be given to them. So if that is the case, they have to go to the labor court.
He was part
of the whole argument. That is why the division benches. My lord, no, my lord. That's why division benches entertained the appeal. My lord, the division benches order.
Not something which can be disputed. If the names of the petitioners are there in records of that case before the tribunal, then
that was the ground on which the learned single judge dismissed the writ. The division benches said that no, kindly see, let us read, kindly permit me to read the division bench's order in that case. And this is, where is the division bench's order? Kindly see the division bench's order, my lord. That is the whole ground on which they have succeeded before the division bench. My lord, I had handed over the.
Yes.
Kindly see the division bench's order, which mentions all the facts. The present challenge, my lord, kindly see para 1. The present challenge has been preferred by the petitioners in all 4 writ petitions against a common order passed by the learned single judge. The learned single judge, by the impugned judgment and order dated March 15, 2024, dismissed all the writ petitions on the ground that petitioners had been abusing the process of law, choosing the forum, suppressing facts, and had been litigating the matter even after question of regularization had attained finality. Thus, the learned single judge did not enter into the merits of the case of each of the petitioners as to whether they were entitled otherwise to regularization of their appointments. Upon hearing learned counsel for the parties, it transpires that certain facts which form the backdrop of the case are required to be gone into for the purpose of complete adjudication of the appeals. At the outset, it may be noted the case of P. Vaikunta Rao, appellant in Mat 14 of 2024, is distinguishable on one factual aspect from the others. Before entering into such particular facts in the case of Vaikunta Rao, the common factual matrix applicable to the appellants is taken up for consideration. The appellants were a part of total number of 136 daily rated Mazdurs who had filed a labor case, giving rise to industrial dispute case number 3 of 2002, in which award was passed on July 13, 2005. The said award primarily revolves around the rights of the applicants therein to daily wages at the rate of 1 by 30th of the pay at the minimum of relevant pay scale plus DNS allowance. In the award, appropriate directions were passed in this regard. However, insofar as the rights of the appellants to regularization of their service are concerned, the same was categorically left open by the labor court to be decided by the authorities with the observation that authority shall consider the same subject to the availability of vacant posts in the department and subject to their fulfilling the process of recruitment in accordance with the extant provisions of the recruitment rules and the general administrative instructions. Thus, up to that stage, it is clear that question of regularization was kept open. The division for
I don't want to go anywhere more. Show me the order of the tribunal, 13th July 2005. According to the petitioner, regularization was allowed. And according to the respondent authority, this was kept open. Show me the order of the
No, this
tribunal.
is the, my lord, the finding of the division bench.
Yes, let us see whether the finding must be based on certain records.
Page 49, my lord,
Yes.
clause 6.
Page 39.
Page 49.
49. Yes, 49 is the order of the division bench. 49 of what?
49 of the writ petition. my lord.
Order of division.
I am having the writ petition number 94.
Yes, my lord.
49 of the writ petition is the order of the division bench.
I'm
in-
sorry, my lord. I'm sorry. The page number would be, my lord.
Page 41. 41 is the operative part of that award. For 39 it begins, the award,
39 it begins.
and
Award.
41.
Show me that
Roman 6.
regularization has been
Romans-
directed.
Roman 6.
Roman 6.
Matter concerning regularization of services of first party workmen is left open to be decided by the second party with the
Yes.
observation that this is what the division bench has said.
No,
So where is it
my
decided?
lord, thereafter Uma Devi came. Uma Devi
Whatever.
came. My lord, what is my case? My case is of discrimination. Uma Devi came, my lord, by taking this clause. They have regularized the service of 122 and did not regularize the rest of them. The rest of them are before my lord on the ground of discrimination.
I get it. You can raise this point before the
My lord,
tribunal.
kindly appreciate, my lord. This can be, my lord, let him make the submission if my lord sees the maintainability. The division bench order, my lord may kindly come to page para 42. Para 42 of the division bench judgment. It starts from para 41 at page number 13 perhaps.
Yes.
My lord may kindly see at this junction. Got it, my lord?
Mhm.
Learned at counsel for the respondent raised an objection as to maintainability of the writ petition from which the present appeal arises on the ground that equal efficacious alternate remedy was available before the tribunal. Now, my lord may kindly see para 42. A careful scrutiny of the impugned judgment of the learned single judge reveals that such point of maintainability was never raised before the learned single judge by the respondent. As such, it would be unfair on the petitioner appellant to be settled with such objection at the belated junction. Moreover, it is well settled that available of an alternate remedy is not an absolute bar, provided, of course, the test of interference under Article 226. My entire case lies on discrimination. We all were party before the labor code, 136 persons, 122 persons were given the benefit. This rest of the persons were not given the benefit.
That is obiter
I say
dicta.
this is a
That is obiter
It is
dicta.
not
Kindly
obiter
read
dicta, it's
43
a
and
finding of the
44.
court.
43,
Finding of the
then 43 will be destructive of the final decree.
If
43 and
at
44.
the initial stage in 2005, there was a direction for regularization and it was open-ended.
My lord,
There was no mandatory direction to regularize.
my lord, because on that day, this judgment was not there and the court cannot direct for regularization, my lord.
Couldn't direct.
Yes,
Thereafter, they did not take any steps. Uma Devi came in.
my lord,
You are aggrieved.
my lord.
Why will you approach this court and not the tribunal which passed the order?
Look, if I could have appreciated the situation, no scheme is promulgated, nobody is regularized, then we have to go. But here a scheme was
All
promulgated.
these things can be raised
A
before the
scheme was
tribunal. No.
Promulgated, 122 persons were given regular appointment and we were left out. And my lord sees the ground of lefting out as the ground which they have taken in there, saying.
The ground may be a very bad ground, but get it done from the labor.
In fact, if there is no scheme, then they may have approached the
come.
writ court. When there is a
Please
scheme,
come.
it is completely factual dispute.
The matter relates to regularization of daily rated mazdoors. So it appears that the petitioners approached the learned tribunal praying for equal pay for equal work praying for giving benefit to them in terms of the office memorandum dated 7th June 1988 and also seeking regularization of their service stuff. The tribunal vide award dated 13th July 2005 in ID case number 3 of 2002 within bracket 136 daily rated mazdoors within bracket as per annexure A under the divisional forest officer comma Baratang represented by the Baratang Forest Workers Union versus the divisional forest officer Baratang upheld the prayer of 122 workmen for grant of wages at the rate of 1/30th. Achha. For not 122. The
To all of them as.
once again upheld the prayer of the workmen for grant of daily wage at the rate of 1/30th of pay at the minimum of the relevant pay scale plus DNS allowance in terms of the office memorandum dated 7th June 1988 from the date of their initial engagement till 31st August 1993. Stuff. The tribunal, however, left the issue of regularization of the service of the workmen open to be decided by the employer. And the same was subject to availability of vacant posts in the department and subject to fulfilling the process of recruitment in accordance with the extant rules and the general administrative instructions. Paragraph. The petitioners submit that out of the total 136 workers who approached the tribunal, 122 of them have been regularized, but the
Regularized in terms of the scheme of.
Regularized in terms of the scheme floated by the administration, but the petitioners have been left out. Stop. Discrimination has been alleged. Stop. Paragraph. Prayer has been made to treat the petitioners in the same manner as the other 122 workmen in ID case number 3 of 2002. Stop. Paragraph. The prayer of the petitioners was considered by the Honorable Single Judge and vide order dated 15th March 2024. The Honorable Judge was of the opinion that the question of regularization of the petitioners attained finality and the writ petitions stood dismissed. Paragraph. On an appeal referred against the said order, the division bench considered the prayer of the petitioners and with a judgment dated 19th June 2024 was pleased to remand the matter back to the learned single judge to decide the issue of maintainability of the writ petition. Paragraph. Upon hearing the submissions made on behalf of both the parties and on perusal of the materials on record, it appears that the petitioners on the earlier occasion approached the tribunal for relief.
No, my lord, these petitioners.
You said they are in ID 32.
Tribunal.
Uh-huh. What did I say? Approach the tribunal with their prayer for regularization in ID case number 3 of 2002. Stop. The authority, comma, for reasons best known, comma, regularized the engagement of 122 workers out of 136 workers as per the scheme floated by them. The court has not been made aware as to why the service of the petitioners was not regularized.
That has been mentioned in the affidavit in opposition.
Very well. In the event the petitioners are aggrieved by any act of the authority in not regularizing their service, including the point of discrimination, comma, the petitioners ought to have approached the learned labor court for necessary relief. Stuff. The writ petition at this stage, at the instance of the petitioners, will not be maintainable. Stop. The court is convinced to arrive at this decision with regard to the non-maintainability of the writ petition at the instance of the petitioners in view of the law laid down by the full bench of the Calcutta High Court in the matter of Avdesh Singh versus Union of India, reported in 2013 SCC Online Cal 9458. And also relying on the judgment delivered by the Honorable Division Bench of this court on 30th August 2024 in MAT 50/2024 in the matter of Venkatesh Kumar Singh versus the administration of Andaman and Nicobar Islands and others. Stop. Next. In view of the above, the instant writ petition stands dismissed. Stop. It will be open for the petitioners to approach the competent forum for relief.
Other three matters, they were not a party. We said
John Ikka and others.
this was disposed of. They were a party.
They were a party. Yes.
The other three,
They
were not a party.
then a little bit of difference in the reasoning will be there, but then. And here also the prayer is regularization.
Yes, same. They were also
I'll make the necessary changes. The order remains the same.
but they were not a party.
They are not a party. 7, 8, and 9.
My lord, that observation, my lord, that we have not pointed out to your lordship why they are not eligible, my lord. That may be.
You say that is there in the opposition?
That is with that this my lord may only in my humble submission, my lord.
I'll delete that line.
Just that line may be deleted.
Very well. The portion where it is mentioned, the reason, the court is not aware of the reason as to why they have not been regularized. Please delete that line. Item 10.
Item 10. WPA 10 Yes,
My lord, I am appearing for the petition. My lord, please, petitioner. He is a 80% Divyang. He was engaged in the employment of Port Blair Municipal Council in the year 1991 sometime, my lord. 1993, there was a scheme promulgated by the government which says that those who are in service up to 1st September 1993 and completed 240 days, their service will be given regular. That has been done. He was regularized from 1st September 1993. My lord, all along he worked under this BBMC. My lord, on 5th of August 9, a so-called notice was issued to him, my lord, on 5th of February 2014. My lord, may kindly see this.
Here also the same point can be raised. Why will
No, this is autonomous.
this
It's
is
not covered.
not
Labor code they can go.
No,
Labor
it cannot be. It is an autonomous body. He's a regular employee, my lord.
autonomous body writ petitions are
Yes,
maintainable.
autonomous body. Now, my lord.
Yes.
Kindly
Labor
come
code
to the
option is
SOCOS.
there.
No, it is not there. SOCOS. Kindly come to the SOCOS notice, my lord, page 42.
There
Yes.
is a, I'll make my submissions after my learned senior.
Yes, yes, certainly.
Whereas Port Blair Municipal Council has been received a number of application under Right to Information Act from the applicant, madam. Work charge Mazdoor attached to water section so and so. In his capacity as branch manager, president, All India Crime Reforms Organization, Andaman Nicobar Island, such and such. He has not obtained permission from the council to enroll him as member of the said organization, which is blatantly violative to Rule 6 of the Conduct Rule with Rule 27. My lord, this is one of the allegations. Thereafter, it says, Mr. So and so is seeking information, putting objection under right to it on the working functionary of the council where he is employed. He is also putting an application under Right to Information Act, seeking information of the working of various departments of the administration. In his capacity as branch vice president, All India Crime Reform Organization, he also attended hearing conducted by the appellate authority on the appeals filed by RTI in various departments during working hours without obtaining permission from the sanction. Thus, he has violated sub-rule 1 of Rule 23 of the Rule 3 of the CCS Conduct Rule and Rule 27 of the Municipal Rule. So and so is directed to explain. So, my lord, these are the two faults on the basis of which so-called notice was issued. Now, my lord, I furnish my reply. My lord, may kindly see. Next.
Why don't you sit, Mr. Chalk? You can sit.
Well.
Yes.
Page 43, third paragraph. It says, with reference to your purported allegation. What is it? At para 1 of not taking
No,
permission.
tell me one thing. Has any punishment been awarded?
Dismissed from service, my lord.
All right.
Dismissed from
And
service.
this is under challenge.
This is under challenge.
All right.
Now, my lord, I am just showing these two paragraphs. My lord, kindly see. With reference to your purported allegation of not taking permission of the council, it is to retrieve that it does not attract the provision of conduct rule, since it is a government registered organization, registered with the Registrar of Society NCT Delhi. Registration which does not require seeking for any promotion for enrollment of any government servant who want to eradicate corruption and social justice at any level. With reference to the purported allegation of making RTI application, appeals in the name of the organization is highly controversial, contradictory, concocted, so and so, and purpose with malicious, malified, and ulterior motive, intention to defame and discourage an individual to expose election corruption. In this context, all the allegation of making submitted RTI application and preferring appeal are unfounded, false, concocted, and fabricated. Since till date, neither I have made any RTI application nor preferred any appeal in the name of the said organization as proclaimed, which would be evidence. So, my lord, these are the two reply I have submitted. First, my lord, for the purpose of, my lord, I will show the rule that rules are nowhere it is having any applicability, my lord. And then second, RTI, he categorically said that at no point of time I have made any application. Now, my lord, after this, he was suspended. Page 45. He was suspended. Now, my lord, it says, whereas a disciplinary proceeding against so and so is contemplated. Now, therefore, the undersigned under rule so and so has placed you under suspension with immediate effect. Now, my lord, after this suspension, a memorandum of charge was issued. Next page, my lord. 17th April 2014. Now, my lord may see article of charge at page 47. First is, my lord, the same charge which is there in the so-called notice. Second, my lord, the same charge which is there in the so-called notice. Now, my lord, some more charges were incorporated. It says, so and so while functioning under so and so submit public grievances of LG Health does in the capacity of General Secretary of Handicapped Persons Association, charging allegation against his own department as well as various departments under Andaman Nicobar administration. He has not obtained permission from the council to become a member of the association. Thus, he has violated Rule 23, Sub-Rule 1 of CCS conduct.
Does this association exist?
Yes, my lord.
It exists.
Exist.
And is the petitioner anyway related to this association?
This is handicap, my lord. He is also a Divyang, my lord.
Yes, but then is he a member? It's not that anybody who is a handicapped person will become a member.
No, in here it is written in his capacity
Secretary.
as General Secretary.
So he was the general secretary of the association.
Now, my lord, this is the third allegation. Thereafter, my lord, while functioning as work charge Mazur is in a habit of leaving his workplace during duty hour without the knowledge, permission of the superior. During the inspection conducted on 21st February 2014 and 25/2/2014. My lord, these are the 2 dates. By the administrative, it was noticed that Sabu did not turn up duty till 3:30 p.m. Thus, he has violated Rule 32. And lastly, my lord, this says that Sabu was acting as self-styled secretary, public grievances without any authority of law and valid document and cheated the general public. He also made fictitious complaint against the staff of Directorate of Shipping Service, Directorate of Science and Technology, alleging that they have accepted bribe under so and so. So, my lord, these are the allegations. These are the allegations, my lord. On the basis of this, my lord, disciplinary proceeding. Now, my lord, first point is that, my lord, will find that SOCO's only 2 allegations. At the time of issuance of memorandum, they expand the scope of these SOCOs. Now, my lord, may kindly see, subsequently he was revoked. After issuance of this notice, he was revoked. My lord will get the revocation order at page 56.
Revocation of suspension.
Suspension.
All right, page 56.
Page 56, it is there. And thereafter he reported duty. Now, my lord, may kindly come to page 53, his reply to the charge memorandum.
Yes.
Second paragraph. In this context, it is to be retrieved that all the allegations so and so are denied and disputed, that none of the charges are related to my nature of duty, and almost all the charges framed against me are related to extracurricular activity beyond duty hour, which are highly controversial. As the matter of fact, the charge against me under Article 1 is highly controversial. But Article 1 and 2 I have dealt with, I am not dealing. Article 3 of the allegation are totally so and so, and due to the very fact that being a general public, there is no restriction in exposing the illegality and irregularity, since I am not a slave of so and so, and exposing the illegality and irregularity of this so and so is not a crime, since the whole intention of the Lieutenant Governor helped us is towards resolution of the general public grievances, hence I have not violated any of the rules. As regard Article 4 of the allegation are totally controversial, contradictory, disputed and denied due to the very fact that the charge has been framed intentionally with vested interest by the illegal designated administrative officer in connivance with John Matthew, the illegal promoted organizer, and hence there is no violation. And lastly, fifth one is says totally so and so, and there is said, and the contention propaganda of unconditional apology for forgiveness is totally unfounded and is to the contrary, and it has the staffs of the so and so who pleaded guilty of non-reception of illegal gratification for so and so. The allegation by them is highly so and so. These are the reply. Now, after this, my lord, an inquiry was conducted. My lord, the report of inquiry officer is at page 59. Now, my lord will find during the inquiry, my lord, 3 persons were examined. My lord will get it at page 64. PW1, one AK Paul was examined, executive engineer, my lord. I will just read out their deposition at the subsequently, my lord. Thereafter, my lord will find next page, page 65, one Gopal Krishna was examined, and same page at the bottom, my lord, one Shyamlal, higher grade clerk, was examined. These were the persons who were examined. Now, my lord,
Did
Now-
you produce any evidence?
No, no, ma'am. Now, my lord, this
No
evidence is
witnesses.
not pertaining to this evidence is pertaining to 2 days absent.
All right.
Only on that score, witnesses were examined. I will show, my lord. They say that at no point of time I have obtained any permission to be a member of that crime association. And secondly, that on 21st and 24th, when I was absent, I was not present at 3:30 p.m. That they have said that when we went, he was not there. These are the two. Now, my lord, may kindly see page 66.
Yes.
It says the inquiry was conducted on 4th of January 2019 to record the statement about the article of charge leveled against so and so. The administrator officer was in other meeting with the so and so and other superintendent, attended the inquiry on behalf of the administrative officer, clarified that Shabu was not given any authority to work as secretary so and so, so and so. Thereafter, my lord, on behalf of the administrative officer, produced a letter from the superintendent of so and so, proving the complaint against the staff of director so and so. Furthermore, on behalf of the administrator, stated that he has violated sub-rule so and so. Further, the charge official has submitted apology letter requesting to forgive him. The office, on behalf of the administrative officer, hereby direct to submit the exact appropriate rules as mentioned in the article 5. Thereafter, my lord, conclusion. My lord, may kindly come to the conclusion. Page 67. As inquiry was conducted by PBMC office, and it was revealed that available document of article 1 to 5, statement of witnesses 1 to 3. And further, also the written statement submitted by Sabu in his article of charge, it is concluded that Sabu is found to be guilty of misconduct, violating of rules such and such for the article of charge against him. Further, in his written reply, he stated that the paragraph rules are not applicable on him. My lord, he has categorically stated that rule is not applicable. I will show, my lord, that are not applicable to him. And it is ID rules and which is governed. However, the statement given by the state witnesses and other documents were clear that no such standing order exists in PBMC. Further, all the staff of PBMC is governed by CCA rule, Andaman Nicobar Municipal Service Classification and Control Rule. Therefore, Sabu was found breach of this such rule and offense amenable to disciplinary action. Now, this is the report of the inquiry officer. Now, my lord, on the basis of this report,
Is the Andaman and Nicobar Islands municipal classification
there.
rules different? It's different from the CCA
my lord,
rules.
they have their own rule also. They are mutandis, both are applicable. So, though provisions which is not there, then CCC, because the notice the entire proceeding was initiated under Rule 14 of CCA rule. My lord, may kindly come to page 68 is the order of the disciplinary authority.
Yes.
29th November 2019. Now, my lord will find the first page is article of charges. Kindly come to page 69. It says, whereas a copy of inquiry report was forwarded to the charge officer, whereas Sabu, without submitting his reply, another complaint so and so, whereas the undersigned as being disciplinary authority has gone through the inquiry report, including the statement of witness and other material submission and the service record of so and so. Thereafter, my lord, this resolution says council unanimously resolved to impose major penalty as provided from so and so. The rules were quoted, and whereas the undersigned, taking into consideration the totality of fact and circumstance, reply submitted to the charge officer in his service record, and after careful consideration of the material on record as aforesaid, and also the report submitted by the inquiry officer, has come to the conclusion that Sabu has been proved beyond all reasonable doubt. Further retention of so and so is not at all desirable, and therefore, my lord, he was dismissed from service. He challenged it before the statutory appellate authority. Now, my lord, kindly come to the order of the appeal was filed at page 71. My lord, may kindly come to page 86. This is on 15th of October 2020. It says, my lord, may kindly come to paragraph number 3. And whereas Sabu filed an appeal before the Honorable Administrator through Secretary, praying to pass certain orders and to set aside the order of the penalty. And whereas the following documents were found not available, shortcoming found in the record of the inquiry proceeding. Thereafter, these records are there. And whereas the Honorable Lieutenant Governor has directed to re-inquire into the matter on the above mentioned point and take further necessary action as per the extended rule provided. Now, therefore, the undersigned in exercise of the power so and so read with so and so hereby appoint as inquiry officer to re-examine the issue. My lord, the moment that order goes, I have to be reinstated in service. That was not done. I remained dismissed, though that order never existed. Now, my lord, after this, my lord may kindly see the statement of the witnesses. After this statement of these witnesses were taken, my lord. Page 91. 3 witnesses are there, my lord.
Page 91.
91, my lord.
Yes.
Statement of that is PW1, that AK Paul.
Yes.
As per the inquiry officer, AK Paul, the one is the re-inquiry on so and so. The inquiry officer deposed that as the charge sheet, the SI state that is sticking to the statement by him in earlier so and so posted under him in the water where I was posted as per article. Sabu while functioning on so and so, no application. My lord, kindly have a note. No application was routed through me or the office for obtaining permission from the council to enroll him as a member of All India Crime Association organization. Sabu did not obtain any requirement. My lord, this is all about this. Permission was not accorded to be a member of the All India Crime so and so. This is not disputed by us. We say that it is not required. Now, my lord, PW2. My lord, he also, my lord, will find at paragraph number 4. Same.
Tell me one thing, what is the requirement of this All India Crime Reforms Organization? He claims to be a member of this organization.
My lord, on the basis of this, he has made certain complaint to eradicate the crime. So that definitely hits somebody
on the basis of this means on the basis
of his membership of All India Crime.
But then at one point of time, I saw he has mentioned that I am not a member. Here also it mentions that he is not required to get himself enrolled. What does this mean?
He say that for the purpose of to be a member of All India Crime, no permission is required from the authority.
All right.
Because the authorities.
So admittedly, he is a member of this All India Crime. He is a member.
That is not disputed.
And for the purpose of obtaining membership, he did not obtain any permission from the authority.
Yes.
From his employer.
Yes, employer. That is not required because the provisions which they are quoting, that is altogether different. If you are acting against the interest of the sovereign of the country, in that case, this permission and all, whatever may be, that provision deals with that, not with this.
All right.
So, my lord, this second witness also on the said score. My lord, para 4, if my lord sees, para 4, my lord. Sabu has not obtained any permission from the council. So, these 2 witnesses were examined on this count. RTI and all, they have not examined anybody. There were 5 count. This is first. Now, my lord, PW3 is the last witness. This witness says, state about the day when they visited and he was not there in office at 3:30 p.m. after. I so and so was accounted as per article. I accompanied administrative officer for inspection and he found that he was not in office till 3:30 p.m. So when they visited, he was not there. Now, my lord, after this, these are the 3 witnesses. I will show the provisions of law. After this, my lord, the authority, disciplinary authority, once again passed an order, page 94. Now, my lord, may kindly come to para 6. Page 94. It says, whereas the re-inquiry report submitted by the inquiry officer was examined by the vigilance branch and found to be in order. Got it, my lord? There is no scope for sending it to vigilance branch. Once an inquiry is conducted, after culmination of the inquiry by the inquiry officer, it will be sent to the disciplinary authority. Disciplinary authority either may agree or disagree. If he agrees, he gives a he will forward it to the charge officer. Now, my lord, IO concluded the evidence put forth by the prosecution, Article 1. Now, my lord, Here, my lord may kindly see, because here I will show the rules, my lord, because the finding, if my lord sees, kindly see rule 6 of the conduct rule. They say that you have violated this since you have not obtained the permission. My lord, I have 2 copies of conduct rule, my lord, may kindly. That is CCA rule, I will come, my lord. First is conduct rule, my lord.
Yes.
My lord, may kindly come to rule 6, my lord.
Which page do I get it?
My lord, the page differs, my lord. This is
Rule 6.
rule 6, my lord. At the top, it will be.
Yes, I see. Joining of association
My lord,
by the government servant.
my lord.
All right.
My lord, kindly see, no government servant shall join or continue to be a member of an association. The object or activities or which are prejudice to the interest of the sovereign and integrity of India or public order or morality. My lord, I being a government servant, I can join any association. We can form association, my lord. There is no bar unless and until it affects the sovereign and integrity of India. So I say, my lord, rule 6 has got no manner of application. So therefore, the entire charges and the 2 witnesses which were examined for the said purpose did not sustain at all, my lord. Now, my lord, if my lord sees rule 27, I will come to 27, that is the municipal rule. First, I will show conduct rule and CCA rule. Now, my lord, may kindly come to the second article, my lord. Second article, he says that you have applied for RTA. My lord, kindly have a note of this. He says that Sadhu, while functioning as so and so and seeking information during office hour under the Right to Information Act, he attended RTA hearing and on duty so and so. He has violated rule 3 and rule 7 of the conduct rule. Now, my lord, pausing for a minute. Now, my lord, no witness was examined on the said score.
Whether he attended the hearing or not.
Because no witness was examined. And from day one, when so-called notice was issued, I categorically, my stand is that you show one document that I have ever appeared or I have made an application for RTA. No witness was examined. Now, this charge was also proved. Now, my lord will find this provision are not applicable. If my lord please, I can show, because the facts are not proved. Therefore, the law will not come into it. But if my lord desire, I can show that rule 3 and rule 7 also, that has got no manner of application. My lord may kindly see rule 3. My lord, what is rule 3, my lord? A general instruction to all the government servant, how they have to act as a government servant.
Yes.
Now, my lord may kindly see rule 7. Kindly see, my lord, rule 7.
Yes.
Got it, my lord?
Yes.
Demonstration and strike.
Right.
Where he had carried strike or demonstration, my lord?
Nothing.
Nothing. My lord, the authority who is passing the order, knowing fully well, I will pass the order, you challenge it before the court of law and you linger on for years together. No, my lord. So this charge was never, my lord, there is any evidence on the said score, nor, my lord, these are having any manner of application. Now, my lord, we see charge number 3. Charge number 3 says, while functioning as work charge under water supply, in the capacity of so and so, he has not obtained permission from the council to become a member of the said association. Thus, you have violated rule 23 of CCS conduct rule. Read with so and so. Now, my lord, for this also no witnesses were examined. My lord, may kindly see rule 23. If my lord sees conduct rule.
It is interpretation.
My lord, it's interpretation. And my lord, it is not that in one place they have written. Right from so-called notice, they are writing this. So, my lord, for this charge also no witness was examined. Rather, the sections which are quoted, my lord, wrong quoting of section will not take away the right if it is otherwise provided under the law. But my lord, when you repeatedly say that these are the violation and thereafter you have accorded me the highest civil punishment. Now, my lord, thereafter, my lord, allegation number 4. Shri P.S. Sabu, while functioning as work charge Mazdoor under so and so, is a habit of leaving his workplace during duty hours without permission of his superior. During the inspection conducted on 21/2/2014 and 24/2/2014, it was noticed that Sabu did not turn up till 3:30. Thus, he has violated 32.2.a of CCS leave rule. Now, my lord, first of all, if my lord sees the evidence, there is 1 day. Assuming for argument's sake, I accept these 2 dates. I say that I was not present. Now, what is the allegation? He was in habit of leaving his workplace. Then they have to demonstrate before the court, before the disciplinary proceeding that yes, all along I was absent. Now, my lord, I am just placing it. My lord, may kindly see 32.2.a at the right hand side.
Yes.
This is leave, my lord. So this has got no manner of application. And I am saying, my lord, to my understanding in this side, I say, my lord, it is not that they were not aware of law. They deliberately done. You do whatever you want. We will do it. Some section at their whimsical, they have quoted those sections. Now they say, my lord, thereafter. This 27, my lord, may kindly see of the municipal regulation. I don't know how it is applicable, for what purpose they want to. What is the procedure? 27 is, they have quoted.
27.
Yes, my lord.
Savings.
Savings.
This is the reason they have referred to the CCS CCA rules.
My lord. So applicability. Now, my lord, so these are the provisions which are quoted in the entire proceeding which was initiated by them. Now, my lord, may kindly see. Whereas the undersigned being the disciplinary authority has gone through the re-inquiry report, including the statement of witness and other material evidence, the submission by the charge officer and the service record of the charge officer, and noted that adequate opportunity has been given to the charge officer during the re-inquiry by complying principle of natural justice. And whereas the undersigned, taking into consideration the totality of facts and circumstance, replies submitted by the charge officer and his service record, and after carefully considering of the material on record, as aforesaid, and also the report submitted by has come to the conclusion that the charges against so and so has been proved beyond all reasonable doubt. Therefore, the undersigned hold good the penalty imposed by the order dated so and so and so and so. Now the question comes, my lord. This order was set aside by the appellate authority. Matter was relegated back and directed to conduct a re-inquiry. Now he reaffirmed the order, which is not at all in existence. And now, my lord, in a disciplinary proceeding, my lord, witnesses were examined. There is a reason for examining the witnesses. My lord, may kindly see from the order. There is no whisper for what those witnesses were examining. What was their testimony? Nothing was, no discussion. Only one line that we have perused the material and arrived to a finding that this is this. Now, my lord, this was challenged before the appellate authority. And the appellate authority, my lord, passed the order at page 104. Now, my lord will find, since the appeal was pending for a considerable period, he approached this court, my lord. Page 106 in the order of the appellate authority, it is there, my lord.
Yes.
the court directed to dispose of. And my lord, thereafter, what he has done, my client has done a blunder, he filed a contempt. Once he filed a contempt, then thereafter, this order was passed, page 107, second paragraph. Now, my lord will find at second para, that whereas on perusal of the appeal dated preferred by so and so, written on submitted by so and so, and ordered by the disciplinary authority, it is evident that the order dated so and so, against which appeal was filed by the appellate, has now been superseded by order after following due procedure. Now, my lord, these two orders are contradictory to each other. The order of the disciplinary authority says, I reaffirm the order passed on 2019. Appellate authority says, I supersede that order. Therefore, my lord, this does not find any merit and the appeal was dismissed. Now, my lord, my grounds are, my lord.
1 minute. Page 107, the bold portion, it is evident that the order number such and such against the appeal has been superseded by the order number such and that means the earlier order gets superseded.
But the disciplinary authority say, I am affirming the said order.
But then both are the same.
No. Disciplinary authority, my lord, that order was.
That order was also dismissal from service.
That has been the appellate authority at the initially. The appellate authority
Set
was
aside.
not set aside.
Remanded back.
He said, reaffirm, my lord.
Very well. The punishment remains the
Well,
same.
yeah,
It is
absolutely.
dismissal from service.
My lord, why
Yes,
am I
yes.
saying so? Once the appellate authority initially set aside that order, in that case, my lord, I ought to have been reinstated.
That is different. Your prayer for reinstatement for the interregnum period after the order is set aside and prior to passing the final order, that period reinstatement is different. But here we are on the merit of the order of dismissal.
My lord.
Yes.
So, my lord, now my grounds of attack is, my lord. First of all, my lord, the evidence which were led was confined to two articles. First, that before being invoked as a member, I have not taken permission, which is violating to rule 6, my lord. And second, that I was found absent. Now, my lord, I say, my lord, on the basis of assuming for argument's sake, if these two charges are proved at all, then also the 3 charges were never proved. First of all, for the first charge, my lord, it is not warranted at all. Now, under such circumstances, no case is proved of. These orders were passed, giving complete go-by to the evidence which were led during the disciplinary proceeding. This is my first ground. The evidence ought to have been taken into account. Then, in that case, the order is patently illegal order. When there were evidence.
Yes.
My lord, I have a argument that so cause notice was issued pertaining to 2 charges. I replied it. They were perhaps not satisfied. They issued a charge memorandum. So whether they can expand the scope of the said so cause notice.
Yes.
Had, my lord, the punishment, if at all, assuming for argument's sake, the charges are proved, whether the punishment is proportionate, my lord. I am a Divyang 80%. My lord, only, my lord, practically no misconduct under section 3 of the conduct rule was ever made out by the authorities, my lord. And therefore, this punishment is disproportionate.
Yes.
This is my submission.
Any decision you want to
No,
rely
I-
upon?
Because on the facts,
Very well.
My lord, my first submission is, my lord, this disciplinary proceeding, my lord, this is akin to provisions, the proceedings under CCS rules. So, my lord, here, my lord, the disciplinary authority and the appellate authority are the sole arbiters of fact And my lord, by means of a writ petition or any further judicial review, my lord, the petitioner is not permissible for the petitioner to seek reappreciation. And also, my lord, the quantum of punishment also, my lord, it is settled law that, my lord, so far as the quantum of punishment is concerned, there also, my lord, the sole deciding authority, my lord, is the disciplinary authority and the appellate authority. So, my lord, the scope of judicial review, my lord, is extremely limited in these matters. But, my lord, before coming to the merits, my lord, as one submission, my lord, which I would like to make without prejudice to my submissions on the merits, if my lord has page 23 of the affidavit in opposition, the rules, my lord, which begin at page 9, this is the Andaman and Nicobar Island Municipal Services Classification, Control and Appeal Rules 2008, which is annexed at page 9 of the affidavit in opposition.
I handed over, my lord.
It is also annexed with the affidavit in opposition. My lord has page 23. 23. There is a provision for review. Rule 20.
After the appellate authority's
Yes,
order,
ma'am.
there is a provision.
Yes, ma'am.
Yes.
Rule 23 says review, notwithstanding anything contained in the rules, the administrator or appellate authority within 6 months of the order, date of the order proposed to be reviewed, or any other authority specified in this behalf by the administrator by general or special order, and within such time as may be prescribed, may at any time, either on his own motion or otherwise, call for the records of any inquiry and review any order made under these rules from which an appeal is allowed, but from which no appeal has been preferred, or from which no appeal is allowed, and may confirm, modify, or set aside the order, or confirm, reduce, enhance, or set aside penalty imposed, or impose any penalty where no penalty has been imposed, or remit the case to the authority which made the order, or to any other authority, directing such authority to make such further inquiry as it may consider, or pass such other order as it may deem fit, provided that no order imposing or enhancing shall be made unless the municipal servant has been given reasonable opportunity.
Have followed the provision.
So, my lord, there is a efficacious, my lord, remedy of review, my lord, before the appellate authority. And it is not as if the, even in the past, my lord, when the first order was passed, the appellate authority set aside the order and sent it back for re-examination of the witnesses. So, my lord, there is a efficacious remedy of appeal, my lord, before about the of review before the appellate authority, which is the lieutenant governor. So, my lord, that option is would have been available to them, and of course, the court may grant them the option again. So, because there is an issue of limitation that may arise. Now, my lord, having said so, if my lord sees the order passed by the disciplinary authority at page 90 of the affidavit in opposition, this is 1st September 2023. My learned senior has gone through the orders, but my lord, my only submission is, my lord, that the orders contain reasons, my lords. If there is a disagreement on the reasons, my lord, that is not a ground, my lord, to file a writ petition, my lord. Secondly, my lord will see the order of the appellate authority, which, my lord, was perhaps not placed in its entirety. So I will just place the order of the appellate authority. Kindly at page 62. This is the order of annexure P8 to the affidavit in opposition. This is the order passed by the Honorable Lieutenant Governor.
Is it not there in the writ petition?
Yes, it is.
I can,
Yes.
I'll show from
Let
the
it go. No, it's red. Let it-
104.
104.
Appellate authority, yes.
Yes, my lord will see. Whereas the Secretary PBMC passed an order under Rule 7, i.e. dismissal from service, which shall be ordinarily be disqualification from further employment, whereas PS Sabu filed an appeal dated 6 January 2020. Whereas while submitting the appeal stated, now my lord, this is not need not be read again. Page 105, whereas the appellant had prayed the appellate authority to admit the appeal, etc. Then kindly see below that. The second recital at 105, whereas on going through the appeal preferred by Shri P.S. Sabu, it is clear that appellant was aggrieved due to procedural inquiry allegedly not being followed in letter and spirit, which is against the law of natural justice. Whereas personal hearing of Shri P.S. Sabu ex WCM work charge Mazdoor before the undersigned appellate authority was conducted on 3rd June 2020 at Raj Niwas, whereas additional submissions were made, whereas additional application filed the appellant is not maintainable. There is no provision either in CCS conduct rules or ANN Island municipal rules for filing additional application. whereas additional points cannot be raised before appellate authority which were not adjudicated at the trial level. Whereas as per sub-rule 2A of 21 of Andaman and Nicobar Island Municipal Service Rule states that in case of any appeal against an order imposing any of the penalties, the appellate authority shall consider whether so my lords, the scope of appeal before the appellate authority is mentioned, whether the procedure laid down has been complied with or not, whether such non-compliance has resulted in violation of any provisions of constitution or failure of justice. Whereas going through the inquiry report as well as order dated 29th/11/2019, undersigned asked the disciplinary authority whether inquiry had been conducted with due process, whereas Shri such and such was appointed as inquiry officer, Shri such and such presenting officer for re-inquiring the matter, whereas in meanwhile, Honorable High Court passed this order, whereas the Honorable High Court in the same matter once again directed respondents to file affidavit of compliance, whereas re-inquiry was completed in all respect and report was submitted by the inquiry officer concluding that from the evaluation of evidence put forth by the prosecution witness and the defense assistant, article of charge framed are proved and found guilty on the basis of material evidence produced, a hearing such and such charges are proved. Whereas disciplinary authority passed an order dated 1st September 2023 stating that undersigned holds good penalty imposed. That is, this is only a reaffirmation in the sense that it is the same order that is being passed. Whereas on the conclusion is the same. After going through the entire procedure of inquiry as directed by the appellate authority in the first round. Whereas on perusal of the appeal dated 6 January 2020, preferred by...
This portion has been read.
Yes, my lord.
You tell me, where is the provision for obtaining permission for being a member of this organization which is there, crime or something?
Yes.
Where is the legal provision?
Kindly see, my lord, Rule 6 of CCS, in the articles of charge, my lord, is clearly mentioned. Rule 6 of CCS Conduct Rule 1964.
Yes, that has been fixed.
Kindly have Rule 6. No, my lord, it is in two parts, my lord. Kindly see Rule 6. Rule 6 says no government servant shall join or continue to be a member of an association, the objects or activities or which are prejudicial to the interest of sovereignty and integrity or public order or morality. And my lord will then see sub-rule 2, which is on the the government of India's decisions. My lord will see authority competent to decide whether the objects or activities of an association attract the provisions of Rule 6. In the meeting of the Committee of the National Council held on 20th January 1977, staff side referred to their request that it should be clearly laid down as to how it should be decided whether the objects or activities of an association attract the provisions of Rule 6, as without such clarification, it was possible for competent authority at any level to proceed against an employee for violation of rule without proper justification. The views of the staff side have been considered carefully as a comprehensive and exhaustive enumeration of various objects or activities which should attract Rule 6 is not practicable, and as the apprehension of the staff side was mainly with regard to possibility of arbitrary action, it has been decided that action for alleged violation can be taken by disciplinary authority only when an authority not below the rank of head of department has decided that the objects or activities of association concerned are such as would attract Rule 6. When the head of department is himself in doubt, he shall seek the advice of administrative ministry department concerned. Now, my lord will see in this case, my lord, the order is passed by the secretary PBMC, which is the head of the department.
Where is the violation of Rule 6? Tell me that he is required to take permission for being a member of this association. The association is with regard to reporting of crime or something. How is it prejudicial to the interest and sovereignty and integrity of the country?
My lord, because my lord, if I can only refer to the articles of charge, my lord will see at page 56. My lord, it appears that this gentleman, in his capacity as the secretary of this organization, my lord, is engaging in disruptive activities, my lord. That
What
appears to
type
be
of
the.
disruptive activities? Where are the evidences that he has taken part in any demonstration, strike, Rule 7 you have invoked? Where are all these things?
My lord, that for that, my lord, the inquiry report has to be seen. Kindly.
And where is the finding that the organization with which the petitioner is associated works against the interest of the country? Or the term is against public order or morality?
Kindly see, my lord, the findings in the inquiry report, which is,
Yes.
I've got, actually, if I may show from the affidavit in opposition, is kindly see page 46.
Is this the inquiry report dated 9th of July 2019?
Yes, my lord.
Which page of the inquiry?
46, my lord, may see.
I am looking at the affidavit of the writ petition. So you
Okay,
give
writ
me the inner
petition.
page?
Inner page is page 2.
Page 2, yes.
My lord will see a statement of kindly see after Article 5.
Yes.
Statement of imputation of misconduct or misbehavior in
Right.
support of the articles of charges. Whereas PBMC has been receiving a number of applications under RTI Act from Shri P.S. Sabu, work charge Mazdoor attached to water supply section in capacity of branch vice president, All India Crimes Reform Organization, ANN Ireland, opposite such and such. He has not obtained permission. He has violated Rule 6 of CCS conduct.
What is this?
Kindly see the
He-
after that.
All right.
Shri P.S. Sabu is acting as branch vice president, All India Crime Reform Organization, and is seeking information, putting objections at RTI on working functioning of the council where he is employed. He is also putting up applications under RTI seeking information on working of various departments of administration and capacity as branch vice president. He also attends hearing conducted by appellate authority appeal filed by him under RTI Act in various departments in working hours without obtaining permission from section in charge competent authority. Thus, he has violated Rule 3 and 7 of the CCS rules, read with Rule 27. Now, kindly see Rule 3.
So from Rule 6, it goes to Rule 3 and 7. Demonstration strike. There is nothing to show that he participated or organized demonstrations or strikes. And Rule 3 is the general instructions to all employees of the government holding government service. Right.
My
So-
lord, the
And
misconduct.
right, if seeking information on the under the Right to Information Act, can that be taken to
No,
be
but
an
my-
offense
But
for
my-
which dismissal is the
My
punishment?
lord, that is, I'll address that separately, my lord. But the difficulty, my lord, is that kindly see Rule 3, my lord. Rule
Yes,
3 of
please.
the CCS conduct rules.
Yes.
Every government servant shall at times maintain integrity, maintain devotion to duty. No, every government servant holding supervisory post shall take all steps to ensure integrity and devotion to duty. No government servant shall in performance his official duty act otherwise than when he is acting under direction. So, my lord, as a government servant, my lord, there is definitely, my lord, and it is inconsonant with the role of a government servant to be member of another association and question the very same department where he is working in. If he was a member of the civil society, it is understandable. But my lord, if one is working within an organization and then at the same time acting as a vigilante, then my lord, there is a contradiction in terms, my lord. It goes against the devotion to duty, my lord. That is how Rule 3 has been interpreted, perhaps in this.
To be interpreted.
Thought to be interpreted. And Rule 7 also, my lord, will see. Rule 7.
Demonstrations and strikes.
Rule 7, my lord, demonstration and strike shall engage himself in a.
Is there anything on record to show that the petitioner participated in a demonstration? He conducted any demonstration or strike? Where is it?
Well, demonstration, yes, my lord, may not be, but it is recorded here that he was,
He sought information under the Right to Information Act
my lord,
against various officers of the same department.
my lord.
Now he is working in a department. He gets to see how the officers are functioning. And
Right.
now if he sees some misconduct at the instance of some officer and he seeks an information under the Right to Information Act, can you take steps against him?
My lord, may I can only place what is there on record. Kindly see, I'll just show 2 pages, my lord. Kindly see after that page 47 of the, this is internal page 3 of the inquiry report. While functioning as work charge Mazdoor under water supply section, PS Sabu was acting as self-styled secretary, public vigilance cell, ANN Island, without any valid documents and cheated the general public of the island. He has made fictitious complaints against staff of Directorate of Science and Technology, alleging they are accepting bribe while issuing pollution-free certificate to private vehicle. Then, my lord, while the PS Sabu, while functioning as work charge Mazdoor and the executive engineer, is in habit of leaving his workplace during office duty hours without knowledge of his superiors. During the inspection, BBMC noticed he did not turn up on duty, and then my lord, there's a separate rule 32(2)A of the CCN.
This is a separate.
This is a separate charge.
Yes.
Then my lord, show cause notice was issued to him. And then my lord will see the legal opinion. Kindly see bottom of the page, 6 March 2014, legal opinion
Yes.
sought from Shri Arun Prashant. I have meticulously gone through show cause notice issued and reply submitted, which reveals that he has made serious allegations against PBMC official as well as authority, which invites immediate action for insubordination, as well as holding post of branch vice president of AICRO without any authority of law. So, my lord, my submission is, my lord, definitely, my lord, whether he has acted in a manner which amounts to misconduct, my lord, has been determined, my lord, by the disciplinary authority, appellate authority. If, my lord, the punishment meted out is found to be disproportionate, my lord, then, my lord, that matter can be reconsidered. My lord, and lastly, my lord, there is a provision for review, my lord, before the Lieutenant Governor. So that
Very-
provision can be exhausted by him, my lord.
Very. Yes. Please come.
No, only one thing. With regard to RTI, no witness was examined. Only he was a member, that was for that charge only. What he has done as a member, no witness. Only.
I will require a photocopy of the relevant rules.
My lord.
Manoj, do we have copy of this?
My lord can retain it, my lord.
No, you have got other works to do. I will not.
Books also.
Doesn't matter, 1 or 2 pages.
My lord.
The leave rules also, the relevant ones.
My lord.
Please make a photocopy. And this CCS was not required, so you can keep this. Heard submissions made on behalf of both the parties. Hearing stands concluded, judgment is reserved.
Obliged.
Item number 11.
I am appearing for the petitioner, my lord. This is pertaining to promotion. It can be taken up
Next week.
Next week.
Very well. By consent of the parties, let the matter appear in the list on 11th. 12th, 11th, 11th.
Item number 12. UPS 6 of 2024.
For the petitioner.
Yes.
A very short point is involved here. Here, the petitioner was appointed in 1999 as a daily rated person by the Portland Municipal Council. Now, a criminal case was initiated against him. And the authorities did not permit him to join duties for certain period. Thereafter, they allowed him to join duty. And in that particular letter, it is mentioned that the seniority of the petitioner will be determined after the decision of the criminal. Now, the persons who were junior to them, they were regularized in 2015. These people, these 3 persons, they were acquitted from the criminal case. They have submitted a representation before the authorities that they have been working for such a long time. Juniors have already been regularized. They have been honorably acquitted from the criminal case. So same steps for regularization and grant of 1/30th of the pay has been granted to us. Regularization and seniority should be granted as like that what has been given to others. Now, the authorities is rejecting the application, saying that they don't have any rules. They don't have any rules even for regularization of other employees. Let them show.
There is a scheme,
No,
no scheme.
that's there, long time back.
Long time back, 1993, that scheme was there.
Yes,
And that particular scheme is
no longer in
no
force.
longer in force. That is one-time scheme.
All right.
So no rule was there even for those employees. But the authorities have taken a conscious decision that those persons who have been working for a long time in the Portland Municipal Council, they will be regularized, and they have taken approval from the Lieutenant Governor. Now, in my letter, when they have reinstated me, in that letter, they have specifically mentioned that seniority will be determined after the disposal of the criminal case. Criminal case, I have been honorably acquitted. Then how can they say that rule does not permit for those persons also?
Very good.
As
It's
of
a clear case of discrimination.
As of now, there is no policy of regularization. That issue is also pending in the Supreme Court.
What
But-
about the others? The
So that at that point of time, my lord,
the rule was invoked.
it's placed, but regularization may have been done on ad hoc basis at that point of
No.
time. But now, my lord,
Complete
the ministry,
regularization.
because my lord, that issue traveled up to the Supreme Court, and the ministry, central government has taken up a policy decision which was conveyed to the Supreme Court that there is no way that we are not going to give money for regularization. So then, my lord, subsequently a writ petition has been filed, which is pending before this court, pursuant to the leave granted by Supreme Court, that your relief is against the central government. So, my lord, the writ petition is pending, where they have sought this relief of regularization from the central government.
This is a
So, my
different-
lord, no, but there is no scheme in existence as on date.
Let them
So-
show in 2015, there was a scheme. What my learned?
As on date, we are bound, we don't have our own money, we have to take from the central government. Central government has filed an affidavit before Supreme Court saying that there is no scheme and this cannot be granted. So because the administration was intending to bring out a scheme for regularization pursuant to orders passed by the division bench. But my lord, when the matter traveled to Supreme Court, the administration filed an affidavit that they will bring out a scheme. But subsequently, the central government informed the Supreme Court that we were not parties, we have not given any consent to such scheme because the money has to be borne by the central government. So therefore, Supreme Court disposed of the proceedings, saying that giving liberty to the
Will this writ petition be kept pending till the disposal of the matter that is pending over here regarding regularization? Because see,
is completely
this
different
court-
with this case.
I think it will be inappropriate for a court to pass mandatory direction for
No, I am
regularization.
not saying that. I am saying that you have taken a conscious decision that seniority will be determined after the criminal proceeding is over. Now, when these particular persons are
Honorably
senior to those
acquitted?
persons,
Yes, then why will the same relief not be granted to you? This is,
they have to recast the seniority.
yes,
and
that
accordingly
means
they have
you have to be regularized first and then only the question of seniority arises.
Because
Now the issue of regularization is pending in court. Will it be
I
proper?
don't think
it is
should not
pending,
be-
it is pending.
Give the case.
No, I will place those documents.
Nothing is there.
No, I will place it.
That is
If
not
there is a
the
doubt, I will
case.
place it.
New cases made.
But that is as on date, there is no scheme for regularization. So how will they be?
Let it show
Because regularization is not a right. Regularization is not a right.
Something has been done by mistake.
No, it's
Can
not
you-
mistake. It's
can
not
you-
1%. It is
Many.
around 100% they have regularized after
Right.
getting approval from the administration. My submission.
But
is-
thereafter certain facts cropped up. The Supreme Court's order, the
That is
pendency
not
of
in
the writ
respect of
petition.
That is in
These
respect of
issues-
everyone. That is in respect of all and DRMs working in the islands. I'll place those orders
They
then.
are an autonomous body.
It-
This is for the municipal council. That
No,
is
no.
with regard to the administration.
None of the scheme
Totally
specifically includes BBMC. I can show the documents. I will show the notifications of Lieutenant Governor. I'll place those documents on
The
record.
regularization always has to be in terms of a scheme or a policy.
That's correct, but
Because there is no law
Proof.
which permits regularization
let's-
as such.
Is proved, dear lordship, then that means a policy decision has been taken by the authorities to regularize the employees, a policy decision. There
Oh,
will not
oh,
be
one
a
minute.
scheme.
Then let them go to the labor court.
Tell
Why should I
me, what is the reason for regularizing those? Under
what
which
I'm saying.
provision?
On
do you-
an ad hoc basis, my lord. Now, unfortunately, my lord,
Saying.
right now, my lord, 2015, what happened, my lord? 2015, what happened if it's a case of, then they should go to the labor court. Their DRMs, my lords, less than 10,000 rupees, they can approach the labor court for regularization. The same argument can be advanced. But my lord, if,
Input I have.
no, point is
You try your luck before the next circuit because we are not willing to grant any relief in this case. Please come. The petitioners seek regularization in service as well as seniority in promotion.
No promotion. In the post comes.
Seniority in the post. Stop next. Learned Senior Counsel representing the respondent submits that as on date, there is no scheme under which the petitioners may be regularized. Stop. The issue of regularization of DRMs is pending consideration in a writ petition before this court. Stop next. Let the matter appear in the next circuit for hearing. Stop. The parties shall advance arguments with regard to the issue of regularization and seniority.
Item number 13, WPS 69 of 2024.
In this case, I just want to have some clarification from my client. He has come today. It will be taken up tomorrow. It is very small.
Very well. On the prayer of the learned advocate representing the petitioner,
let
the matter.
let it be on Monday, my lord. I have some difficulty tomorrow, second half. But let it be on Monday. Ninth. Any day next week, I have no difficulty.
Tenth?
Any day.
10th,
Any day next.
Tuesday,
Any day next week, no problem.
Let it be.
Tuesday, 10th, 10th.
Item number 14, WPA 81 of 2024.
Very well. On the all three matters, 14, 15, and 16. Only-
I'm appearing for the respondent.
1 minute. 14, item 4. Respondents, very well, 14. On the prayer made on behalf of the learned advocate representing the petitioner to file affidavit in reply. The time to file the affidavit in reply is extended till 30th of December 2024. Stop list in the next circuit. When is it valid? Then you are enjoying an interim order and will seek extension of time for filing reply. This is improper. Then let the interim order that is subsisting is extended till the next circuit, till the end of the next circuit.
Item number 15, WPA 82 of 2024 with item number 16.
Lord, I'm appearing for 2 and 3, but the Port Blair Municipal Council.
In 15, I'm holding.
Miss Babita Das is appearing for respond number 1, Your Lordship.
In 16, I am appearing for respond number 1.
On the prayer made on behalf of the learned advocate representing the petitioner, list the matter on 12th.
Item number 17, WPA 90 of 2024.
My lord, here I would be filing my rejoined reply.
On the prayer made by the learned advocate for the petitioner, time to file the affidavit in reply is extended till 30th of December. Stop list in the next circuit.
Item number 18, WPA 91 of 2024.
My lord, I'm appearing for the.
My lord, I am
my
also
lord.
appearing.
Petitioner, your lordship, I say,
This person, matter has become infructuous, then.
It's not infructuous.
Petitioner.
lordship, it will fix Monday or Tuesday.
Why? Why not
Today.
today?
Today I'm not ready. Your lordship.
You're not ready?
Yes.
My lord, it can be taken up tomorrow because, my lord, it's a service matter, my lord. It's not
a
how it is
service
affected,
matter.
I don't know. It's a service matter. How?
He is not.
Court has to decide. Court will
My,
decide.
my
He's a retired
service,
employee.
my service
Retired.
affair was challenged. I retired from service. He's nobody. He's not in the employment.
No. I initiated a proceeding against him and department illegally exonerated him. That is the proceeding.
How it is maintainable? It's a service.
This is, I cannot go for the department because I am not concerned with the service matter.
Anyway, on the prayer of the learned advocate, on the prayer made by the learned advocate for the petitioner, list the matter on when?
Tuesday.
10th.
Item number 19. WPA Dipalana 2024.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. List in the next circuit.
Item number 20. WPA 124 of 2024.
Your Lordship, I am for the petition, filed the reply.
My lordship, I am for the private respondent.
Copy.
Copy, sir. Copies.
I've given the copy to the.
You will give the copy today?
No,
To
copy
the-
has been served, right?
To the authorities, I have given it today. ये तो आपको पहले मिल गया।
Maybe actually.
We have not received copy. Yeah. Copy may be given to us. Rakesh, no copy.
Copy of the affidavit in reply is yet to be served upon the learned advocate representing the respondents. The official respondents. Let copy be served.
I'm serving today.
List on 11th. I'm fixing it on 11th.
Your Lordship. ऐसे तुमको नहीं देना तो उसको देना ठीक है
हम देख
इसमें इसी में एक कॉपी दे
क्या कुछ
Item number 21.
अब
WPA 136 of 2024.
Where is the petitioner? None appears on behalf of the petitioner at the time of call. List in the next circuit. Appearance of the respondent may be recorded.
Item number 22. WPA 167 of 2024.
Only not today.
It will come on Monday.
No, Monday there are a lot of matters. Who is for the respondent?
I am appealing.
What is the
My
matter?
lord, they are seeking compensation for wrongful arrest, my lord. That, my lord, there are provisions in the CRPC and
Yes.
BNSS which they can seek, but won't let it be on Wednesday.
Wednesday.
Whenever, when I am not.
Accommodation has been sought for on behalf of the learned advocate representing the petitioners. List on 11th.
Item number 23. WPA 190 of 2024. With Title 34.
Yes, please.
They are seeking extension, my lord.
Lordship, enough of extension has been given to them. They are not filing the
Next week we'll
affidavit.
file it by
For
next
what?
opposition.
Enough of time has been given. Your Lordship may kindly see.
There are
In
two
both the
matters.
cases, they never
Yeah,
filed
no,
an
one matter
objection.
we have filed, one matter we have.
No, I have not been served with
Copy
any
doesn't have-
copy.
Both means 23 and 24.
Yes,
Which one matter we
very
have filed?
pathetic, Your Lordship. It's a very pathetic case. One, Mr. Kurmarao. He was serving with the department.
The private respondent is also not there.
He is not the present, but I have served him.
No, but
Also,
now.
also he was present.
Fighting, so the other one is not there, my lord. How can it be heard
Two
without?
wives are fighting.
Yes, my lord.
For
Over the
pension,
service benefit of the deceased
deceased
husband.
employee.
Yes.
So, my lord, anyway, it can't be heard without the other party.
No, if he is not present, I should, I should suffer. Your Lordship, for
Should
past 20 years, I'm
Does the
fighting.
personal law of that employee permit more than one marriages
No,
to take place?
No,
No.
not at
Who
all.
is the first wife? You
Uh,
claim your.
Private respondent is the first wife.
You are the second
I'm the
wife.
second wife.
What benefit are you seeking?
I'm seeking only pension benefit.
And what benefit has been given to the other party?
She is enjoying a government job and she has exhibited herself to be an unmarried woman and she has obtained a job under a compassionate ground.
That you are not challenging. The
That
job
I'm challenging, not here by way
in a
of
separate
separate
petition.
here.
So here your prayer is only for the pension.
Pensionary benefit. Nothing else.
Not there for the.
Civil suit is also pending. and-
Civil suit is also pending.
Then
Lordship, what has happened? After I made a complaint that she has obtained fraudulently this job, so there was a disciplinary proceedings initiated against her. The moment she came to know the disciplinary proceedings has been initiated, she started to, she said, she complained that she is now paralyzed, so she don't want to participate in the disciplinary proceeding. Now she's in her house.
Now, what
And
I
she's
suggest,
still in the job.
yes, she's in a job.
She is getting the salary by
Yes,
staying at home.
Yes. Now, what I suggest, Your Lordship, because it is such a case, can it be referred to mediation? Because now her job is at stake. So I don't want to lose her. No, that was done before the initiation of disciplinary proceedings. Now a disciplinary proceeding is there. There is a report also which I came to know from my own sources that her job is at stake now. She will not get
My
anything.
lord, the issue has already been decided by this honorable.
If my learned brother is not helping,
Do you lay any claim with regard to pension?
Yes.
Or
So,
your
if
claim?
he is insisting, then we have to argue on it.
Pension also, by the order of this
No, but then
honorable.
if you say you are unmarried, then how do you?
No,
claim-
no,
I can show from the document. I can show from the document.
I got the job on compassionate because of death of my father.
No,
Your
I have
father.
been deserted, my father.
you exhibited yourself to be an unmarried woman.
I
I'll
have
show
been
you.
deserted by my husband and remarried to this lady. And the marriage has not been dissolved by any decree of divorce.
It was a customary divorce
And-
then prevalent at that point of
Customary
time.
divorce.
78, in 1978, Your
And
Lordship.
this lady filed an application for succession certificate before the district delegate, and the district delegate has been affirmed that the first wife is entitled to get the pensionary benefit of the husband.
No, that
And
we
that
cannot
has not
decide.
been
That
challenged
district
anywhere.
cannot decide on
That
that.
has not been challenged.
It's a summary
It has been
proceeding.
decided.
That cannot be decided by the court. The court has exceeded the
She
jurisdiction.
already enjoyed the service benefit of more than lakhs of rupees.
She enjoyed.
Yes,
How?
because in the service book, name of the second wife is there. Subsequently, it has been changed.
If your husband has done so, what is the problem with this
That-
lady?
Subsequently, what happened for pensionary benefit, family pension?
Now
This is
when
with
he's
regard to-
gone,
Not the
you have
pensionary
fights.
benefit, my lord. This is with regard to the family pension. Now, when family pension claimed by both the wife. Now it has been decided by the P and account officer, once the divorce has not been taken place, the first wife is entitled to get the family pension. And it has been also decided by the authority concerned also. And that was not challenged initially. And as that order was not executed, I filed the second writ petition, WPA 5 of 2015. They have contested the suit.
Lordship,
In that writ petition, the authority has been directed to release the family pension.
In favor of
Favor of me, first
your
wife.
client.
Yes, and 50% family pension has been released.
Now balance 50 is remaining.
Balance 15 is remaining in the second marriage. There are two issues. First marriage, one issue. Second marriage, two issues. They are also entitled.
Lordship,
Child may be legitimate or illegitimate. They are entitled to.
Lordship, may kindly come to page 82, Your Lordship, her service book. Her service book. Your Lordship may see what she has claimed.
No, in the succession certificate.
Succession certificate, summary
And the
proceedings.
issue has been decided. There is no, this second wife is not entitled to get any benefit of family pension.
Tell me,
So-
where is your legitimate claim?
Lordship,
Second wife. where
admittedly,
is-
admittedly, Lordship, I will not linger the matter. I know that I am the second wife. Legally, there is no divorce deed. So I am admitting that. I am admitting that.
Remains.
So Lordship, what is there? There is a civil suit pending before the trial court to decide the issue. Because she has merely accepted the customary divorce. There are judgments which say
Clever. She admits that she is in the back foot. So don't press her more. Yes.
so. What is my suggestion, Your Lordship? Because now her job is at stake because of my complaint. So what I suggest that if the matter is referred to mediation, both will be there will be a conciliation proceedings done by a mediator who can solve the issue. She will withdraw her complaint and she'll get all her benefits, her service benefits. She'll get it.
You won't get anything.
Then she has to.
She will get everything. You will not get anything because law doesn't permit it.
No, customary divorce, Your Lordship, there are judgments to that effect that once customary divorce was that prevalent at that point of time, because in Andhra, Your Lordship, this was prevalent at that point of time. So she has executed a divorce deed and the panchayat has regulated the thing saying that now you have been divorced.
No,
He has given
by the-
second wife's name in the service
any
record.
authority of the panchayat simply doesn't have any authority to issue any such orders. Never had.
But once
That
she
is
has
right.
exercised, once she has exercised,
Delegate, that exactly the same word has been decided by the district delegate.
It cannot
That
be.
that divorce deed is not valid in the eye of law. That has been
Once she
decided
has
and it is
exercised-
unchallenged.
If this lady, out of her own volition, provides something to you, that is different. But sitting in a writ court, this cannot be done.
That is why I suggested your lordship, let this matter be referred to
What will
mediation.
the mediator do? If you can, if the Mr. Haldar's client, out of sympathy or out of anything, give something to you, can you convince? What does this lady do?
My lord, what
She's,
happened?
she's nowhere
After
working.
death of my
She's
husband,
starving, like, literally
this
she's
second wife
starving.
occupied the entire landed property at Andhra Pradesh. She is enjoying the entire landed property.
Those all
She
things-
enjoyed this.
That is beyond the record, my lord, brother.
Students, foreign gratuity, everything she enjoyed. I filed a suit for recovery of that money. Money suit is pending.
No, I
And she is
don't think
claiming
the
the
court
family
can come
pension.
to your aid in any manner.
Lordship, till the civil suit is decided, your lordship.
For declaration of marriage.
तुम्ही बोल लो सब.
ये तो case है.
What is your prayer in the writ?
My prayer is, the authority decided that I am entitled to get the service benefit, sorry, pension, family pension, being the legally wedded wife, and that has been decided by the authority that should be executed, and that has been executed,
Implemented.
implemented.
What is the stand of the government?
Well, as
We
we
have
are,
not filed the affidavit, so I don't
we
know
are
what is
seeking time
that.
to file affidavit, my lord. Fine.
In both the cases, I didn't
So one
receive
case
any
we have
affidavit.
filed. We'll serve the copy. We have filed in the second matter, first matter.
Give
we
me
are-
the file of the second matter, please. Obligation accept.
It was okay, affidavit. Yeah, affidavit है देवेंगे. I'm going to file for this.
मेरे पास तो है नहीं, आप इसी से पूछ लीजिए.
Yes, in one matter, the opposition has been filed.
But
Kedaramma.
I have not been given with any
I
copy,
didn't
your
give
lordship.
any.
No, opposition filed, I filed the reply also.
Yes, reply is also there. Right.
কি বলেছে দেবে?
Give, please pass on a copy to your learned friend.
He is not having any copy, so he's asking my learned brother.
Please come. Writ petitions are taken up for consideration analogously. Stuff. The writ petitions have been filed by two ladies claiming service benefits of a deceased employee.
Only the
Stop.
benefit. Service benefit already issued.
Already
Family.
as a family pension, not service benefit, but family pension. Stuff. Admittedly, S. Kedaramma is the
First wife.
first legally married wife of the deceased employee. Stuff. M. Damayanti, who claims to be the second wife of the deceased employee, does not have any strict proof of marriage, but only but submits that the marriage between the parties was customary and the first wife accepted the divorce,
Customary divorce.
customary divorce. Stop paragraph.
One thing, my lord, I think I should point out, if my lord sees the affidavit in opposition, kindly have page 12. Paragraph number 10. So this gentleman, my lord, had given a declaration certificate where my lord will find, I have mentioned in para 10, it's also annexed at page, page 49. Kindly see deceased para 10 that is
Yes.
submitted that the deceased late M. Kurma Rao had submitted deed of divorce dated 22nd February 1981, subsequently changed his family members
Yes.
declaration form to the following effect. So in his declaration form, M. Damayanti, that is the
One of the
second
commissioners.
wife, second wife, then my lord will see there are two sons
Yes.
and there is one daughter and his mother. So basically, he has in his declaration form, he has included the second wife and all the children. So my lord will see after that. In this regard, M. Kurma Rao, after marrying Damayanti, has informed department with the divorce document, got entered M. Damayanti's name along with her children and also children of first wife in the service record. As evident, accordingly, after demise of M. Kurma Rao, all pensionary benefits except monthly family pension was released in favor of nominee. So, my lord, we have released other than family pension, everything else has been released in favor of the nominees, which includes the second wife and the children from both the marriages.
The document also appears at page
49.
49.
Yes. What did I say?
That is not.
Do you have anything in your service regulations as to how this issue is to be dealt with?
My lord, we have to give it to the nominee, my lord. The rights are not decided, my lord. That the court will decide, my lord. We cannot decide the
Court decided.
legal
So
rights.
again, you are telling me.
Legal rights we cannot.
Succession court cannot decide.
Nominee,
Family pension?
everything is given to the,
Family pension
No.
given to the nominee? No?
that my lord I have to ascertain, my lord.
Yes.
There is a column that after my.
Kindly see, we have addressed
Who will
that.
draw the
Para-
pension?
Kindly see para 23. Kindly see para 23, page 18. The respondent number 2, with a office order dated 29 July 2021, has issued an order wherein it is mentioned that the required document as called for therein have not been received by the office, and due to non-receipt of the above mentioned document, this office is unable to comply with the direction. Further, pension case was resubmitted to PAO with a letter dated 7 July 2021. Subsequently, PAO with its letter dated 6 July 21 observed that an order would be required from with reference to family pension to be sanctioned and to be withheld for releasing pension. Accordingly, respondent number 2 accorded sanction of family pension in respect of S. Kedaramma and dependent children. So, my lord, that document
So
is
the family pension has been allowed in favor of the first wife.
first wife. As my learned.
50%
Regarding that, it is incorporated in the letter issued by the pay and account, which is at page number 48 of the petition.
And the Kedaramma has already received 50%
50%.
of the family pension areas.
Yes, 50%.
So only 50% is remaining.
Only 50% is remaining.
So you got your share.
No,
No, but the monthly family pension.
Family pension, he is taking, she's
I am
taking.
entitled to it as because the 50% is not released because of the pendency of this matter.
The applicable, my lord, rule is.
What about the relevant, regular family pension? 50% of the areas must have been paid.
50% the family pension.
Pension also.
Oh, you are getting 50% of regular pension.
Here,
And the other balance 50% is
get
the gov-
yes.
organization, the
Yes.
administration.
Well, the rule quoted by the pay and account office at page number 48. As per GID 15 below rule 54 of CCS pension rules 1972. The decree of divorce which was not obtained through the court of law cannot be treated as legal. Hence, the marriage between late L. Kurma Rao and Damayanti cannot be treated legal as per the court order dated 35/2014. Hence, in view of the family pension case may be reviewed in terms of the court judgment. Further, the court has directed to pay the encashment to the that was paid.
The
Second one.
the applicable rule.
Family pension, the rule regarding the family pension that was quoted by the pay and account office.
The rule is, my
Page
lord.
number 48.
Yes, my lord, the rule as is also quoted in the 29 July 2021 letter at page 69, Government of India, Department of Pension and PWOM dated 27/11/2012 and rules, sub-rule 7C of rule 54 of CCS pension rules. Now, these are the applicable rules, my lords. I can produce them, my lord. And right now I don't
Check up
have
and
it.
come back.
Yes.
If any resolution can take
Okay,
place.
produce it for the.
But then mediation is not the proper forum and the mediator will not be able to adjudicate this.
We'll produce
Your
it.
lordship, let my learned brother find out if she gives any no objection, whether I'll be entitled for this thing. Accepting that, yes, it was a customary divorce. If she's giving no objection, in that event, if I'm getting pension, actually she's starving, to be very honest.
You have properties at Andhra Pradesh.
No, it's all, my learned brother never knows about it.
Respectable post, daughter married, son in the Indian army, working in the Indian army in a respectable post.
No, but
Can you show me any document to that effect?
Children suppose not taking care of the mother.
Actually, it is happening, Your Lordship. She's a
can be
maid,
done?
actually, she's a maid
Even though she
in a
enjoys
house.
the entire service benefit.
How much is that?
And
2 lakh rupees.
enjoying the landed property left by my husband.
What is she?
2 lakhs and all, she got it.
What is she doing with the landed property?
She's here serving as a maid.
Getting the lease amount,
Ah.
given for lease. Landed property was given to someone on lease.
What does your child do? Your child,
Private,
he's also getting something.
yes.
He's not a
Private
child,
job,
he's grown up
sometimes
boy for
working
30
here, sometimes
30
not.
years. He's a grown up man of 30 years now.
Anyway,
Even I am not getting any service benefit.
You will not get the job.
50% of the pension,
My
monthly
mother is
pension,
getting, I am not getting it.
your mother means?
Family pension, my mother is 50%, family pension, my mother is getting, but out of that service benefit,
Mother means?
entire service.
Mother means you are the widow of that employee.
Widow. Kiska mother?
Mother is getting family pension, 50% of the family pension, but the service
I don't
benefit.
understand mother. How is mother coming in over here? You are the widow of the deceased employee.
I'm talking about my son,
Oh,
because there are one son out of first marriage.
Yes.
Yeah. He did not get any service
We are not
benefit.
talking about the sons over here. We are concerned with the widows. What did I say? I didn't get it. Once again.
To underline for an episode.
Hmm. 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 Stop. The employee incorporated the name of the second wife in his service records. Stop paragraph. Learned advocate representing the second wife submits that the second wife is in a very penurious state and she requires immediate financial help. Stop paragraph. The senior counsel representing the administration is directed to revert with proper necessary instruction. List on Thursday, I'm keeping it 12th.
My lord.
not.
Item number 25, WPA 203 of 2024.
For the private respondent.
Is nobody there for the petitioner? Petitioner?
Stegmar is on the main and for his treatment. Yes, requested for a.
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. List the matter in the next circuit.
Item number 26, WPA 207 of 2024.
Lordship, my senior advocate Anjali Nag appears on behalf of the petitioner. It is a matter of shop allotment, your lordship, and a review is pending. So I pray that this matter may be fixed on the next circuit.
If the review is pending, why will the writ petition be?
Because in similar matter, orders were passed and then those orders were challenged by the department, by the PBMC before division bench. Division bench permitted the department to file a review before the single judge because their whole case is premised on the order passed in the other matter, which has now been sought to be reviewed before the appropriate court. So let it be, why not next circuit court?
Learned advocate representing the petition, the parties submit that the issue in question is pending in review before the honorable single judge. Stop. Accommodation has been sought for. Stop. List the matter in the next circuit.
Obliged.
Item number 27.
Whereas, affidavit in opposition has been filed, but I'm serving my lord copy.
Copy of the affidavit in opposition has been served upon the learned advocate representing the petitioners in court today. Stop. It will be open for the petitioners to file reply to the same by 30th December. List in the next circuit.
Instead of 30th December, let it be by 7th of November.
All right. By the first week of January 2025. List in the next available circuit.
Item number 28, WPA 224 of 2024.
For the respondents, I filed my affidavit.
I have received, just now I have received, my lord. Here I will be using my reply by 30th of this.
Is the opposition there on record? Please check. Learned advocate representing the petitioner seeks time to file affidavit in reply. Stop. Let affidavit in reply be filed by 30th of December. Stop. List in the next circuit. The affidavit in opposition is already on record.
No.
Item number 29, WPA 2024.
I'm appearing for respondent.
Your Lordship, my senior Mr. Japan Singh for the petitioner, Your Lordship. I'm seeking time for filing reply.
For filing reply on the prayer made on behalf of the learned advocate representing the petitioner, time to file the affidavit in reply is extended till 30th of December.
Yeah, Your Lordship.
Stop. List in the next circuit. Next matter is also same.
Already filed my affidavit in opposition.
Reply.
This is time for filing.
All right, same order. Item 30 also record that the affidavit in opposition is on record.